দোলে তারা বালিকা ফেরো চঞ্চল কত ঝোলে খাম অমর ছন্দে প্রণবলি ঋষি মানুষ ঋগ প্রদীপা প্রজ্ঞাপূরক জ্যোতি সুশীলা চরিত দাপট বিনয়িনী কেন ভারত পরশুয়া কেন করিবা নাচে ছলো ছলো বহে সরস্বতী সিন্ধু প্রবল দৃশোদতি দিল অর্ঘ আচুল স্ফুরিত ইন্দু বিতরণ চলে ভাগীরথী তাকে বলো বলো সাগর দৌত চরণ যুগল তুঙ্গ ধবল গিরিগিরি কেন করিবা করবিনী আর্য ভারত পরশুয়া কেন করিবা করবিনী স্মৃতিপ্ত মহেন্দ্র পুরুষোত্তম চিরমন্ত্র যাবে আহ্বান বিপুল মন্ত্র অমর রত্ন জীবন শান্ত আর্য মরিমা গভীর মন্ত্র ছলকি সত্যায় কৃতজ্ঞ জয় গুরু।
Please be seated.
জয় গুরু।
এটা মাইক দেওয়া আছে? হ্যালো হ্যালো Now I invite Sri Jyotirmoy Das, a senior advocate of Chandanagar Sub-Divisional Court, to make his introductory speech.
वंदे लोक तिलकं सत्तत वार्ता विभूषणम् अमृत कित्तुत्सारणं प्रबुद्ध लोक जीवनम प्रणय प्रमत्त जाग दीपनम जीवन जीवन सत्पुरुषम. Honorable judges, advocates, budding advocates, distinguished guests, ladies and gentlemen, Jai Guru and good morning everyone. This legal fraternity has been blessed by Parama Pujyapada Sri Acharya Dev of Satsang. He obliged by giving the holy name VIDHI-VIDATH, including an emblem. Today, VIDHI-VIDATH started a new journey. We are at the juncture of a historical moment. We take immense pleasure in welcoming you in the All India Legal Academic Seminar in the context of 3 new major acts. That means BNS, BNSS, BSA. Apart from these acts, we included a few warning topics like cyber law, artificial intelligence, electronic evidence, family laws, and intellectual property laws. The main objectives in bringing together some eminent personalities of legal world in order to help prospective lawyers gain from the expertise. The venerated panel of speakers, judges, lawyers, we are truly humbled to be here in spite of their busy schedule. The topic of panel discussion revolves around the future, revisiting the future of legal education in India. We felt it should be discussed amongst the regarded people in the legal fraternity, as it is the topic that should be conversed for the betterment of all the lawyers, both the proficients and analysts. Parama Pujyapada Acharya Dev has blessed us with the name of our fraternity, VIDHI-VIDATH. This is the conjunction of 2 words, Vidhi and Vidath. The word Vidhi means law, which comes from the Supreme Father. The origin of the word Vidhi is from Veda. Vidath was the legal institution of Vedic age, where the scholars of laws argued the civil rights and property rights. We acquired it from Rig Veda. Pujyapada Acharya Dev was graciously pleased to discuss the symbol of and the logo elaborately. Please show the logo. Please show the logo on the screen. The logo if there is technical defect, so that I'm carrying. The logo comes from the Hindu mythology. Lord Vishnu was the supreme creator and sustainer of universe, who himself is law or Vidhi. This is the logo, fantastic logo, blessed by the Param Pujyapada Sri Acharya Dev. The circle indicates the Sudarshan Chakra. Acharya Dev elaborately discussed every parts of the logo. Now, the Sudarshan in Bengali, he described Sammyak Rupe Darshan. We can't reach the exact conclusion without observing the fact all around diligently. Before the pronouncement of judgment, judges are to be require the matter thoroughly. The white swan with wings of both sides is flying. This means the balance in Bengali Shamota. At the time of pronouncement of judgment, judges should have kept in mind regarding the balance towards the plaintiff and defendants, complainant and accused, petitioner and respondent. And the white swan is a symbol of pure heart, unbiased mind, which is required for determining and the delivery of judgment. In Bengali means Sat Chitto. The upward movement of the swan. The upward facing swan indicates spiritual upliftment, passion pervading adherence with Supreme Beloved. The verse written in Sanskrit in the around the circle is written by Paramapujyapada Sishiyacharyadev. Nay niti niddharinomev vyavahar. It means justice, ethics, and meaningful rational adjustment of character. This is the motto of this logo. This is the essence of this logo. Paramapujyapada Sri Acharyadev giving us and is form the upcoming movement of this association, these wings of legal fraternity of satsang. In the context of education, Parama Premamay Shri Thakur Anukul Chandra accentuated his thought. Education and literation is not the same thing. We cannot be literate from education, it can be literate from education institutions, but cannot be educated without adjustment with living ideal. In the legal professional field, juniors learn from the senior. In legal career, respect towards senior, study, constant effort and dedication is the key of success. According to Thakur, education is the systematic organization of habits and instincts with purpose of fulfilling the becoming of life by a graduated active manipulation of behavior may be called education. Furthermore, Sri Thakur also said, education is the unfoldment of our inner tendencies, which fulfill our becoming with a meaningful rational adjustment. I may conclude my inauguration introductory speech with a motto of Sri Thakur Anukul Chandra in the book Message Volume 4. Justice is he. Justice is he who stays his hand to relieve the calamities of the needy, helpless and molested, and clean the evil thereby. Thank you. Thank you. Jai Guru.
Today's honorables and distinguished speakers are Honorable Mr. Justice Apurva Singharai, High Court, Calcutta, Dr. Faisal Fasis, Professor of National University of Juridical Sciences, Dr. Surjo Kanto Boladhikari, Professor of National University of Juridical Sciences, Kolkata, Mr. Bibhas Chatterjee, Public Prosecutor, Cyber Law and Electronic Evidence, Government of West Bengal, Mr. Papai Chando, Learned Advocate, Guwahati High Court, Kohima Bench, and District Judges Court, Dimapur, Nagaland. And last but not the least, Mr. Taposh Kumar Sahu, Learned Advocate, High Court, Odisha. Now I hand over the host to call upon the speakers.
A very good morning to everyone present here. To welcome is to show honor. To welcome is to establish integrity. I am extremely happy to welcome Sri Taposh Kumar Sahu, Learned Advocate from Honorable High Court at Odisha, to come to the dais. Sir, kindly come to the dais to share your knowledge with us.
Jai Guru. It's my immense pleasure now to invite on the dais Advocate Taposh Sahu from the state of Odisha, practicing in the High Court of Odisha, Cuttack, specialized in civil and criminal matters, criminal laws, will now deliver a speech on intellectual property laws. Please welcome Advocate Taposh Sahu. Momento. That's it. Please.
Small token of gift from VIDHI-VIDATH.
A small token of gift from VIDHI-VIDATH.
Good morning. Very warm welcome to all of you. Today, I am very much delighted that our advocate friends and all my brothers and sisters, they have participated in this seminar, and from all over from every corner of India, everyone has come here and participated in this seminar. I am very much delighted. Actually, intellectual property rights, normally we think this is related to only intellectuals. In very short span of time, I will try to cover up all the aspects of intellectual property. After that, we may have a question-answer session. So, the World Intellectual Property Organization describes intellectual property as the creation of the mind, inventions, literary and artistic works, and symbols, names, images, and designs used in commerce. It is mostly intangible in nature. Intellectual property is protected by law. For example, patents, copyrights, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. The development of any society directly depends on IPR and its IPR policy framework. Lack of IPR awareness results in the death of inventions, high risk of infringement, economic loss, and decline of an intellectual era in the country. The origins of India's IPR system date back to British colonial rule, when as a colony, the state enacted various rules and enforcement mechanisms pertaining to IP rights. Post-independence, India retained elements of these structures while updating some guiding regulations and other bureaucratic structures. As India moved towards liberalization, privatization, and globalization in the 1990s and later, Indian policymakers made further adjustments to keep up with the growing needs of domestic and international stakeholders. Indian IPR laws fully conform to the agreement on trade-related aspects of intellectual property rights that is known as TRIPS agreement under World Trade Organization. National Intellectual Property Rights Policy, adopted in May 2016, is a giant leap by the Government of India to spur creativity and stimulate innovation. It lays the roadmap for the future of IPRs in India. The policy seeks to reinforce the IPR framework in the country that will create public awareness about economic, social, and cultural benefits of IPRs among all sections of the society, stimulate IPR generation and commercialization, modernize and stimulate, strengthen service-oriented IPR administration, as also the enforcement and adjudicatory mechanisms for combating IPR infringements. There are various forms of intellectual property like patents, trademarks, copyright, industrial designs, geographical indications, semiconductor integrated circuits layout design, trade secrets, protection of plant varieties and farmers' rights, biodiversity. Let us discuss it one by one. Patents, which is covered under Patents Act 1970. Patent is an exclusive right granted for an invention which is a product or process that provides a new way of doing something or offers a new technical solution to a problem. It provides protection for the invention to the owner of the patent. The protection is granted for a limited period of 20 years. In order to be patentable, the invention must be novel, it must involve an inventive step, or it must be non-obvious, and it must be industrially applicable. Patent protection means that the invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. A patent owner has the right to decide who may or may not use the patented invention for the period in which the invention is protected and the right to initiate legal proceedings against infringement. The patent owner may give permission to or license other parties to use the invention on mutually agreed terms. The owner may also sell the right of invention to someone else, who will then become the new owner of the patent. Once a patent expires, the protection ends and an invention enters the public domain. That the owner no longer holds exclusive rights to the invention, which becomes available for commercial exploitation by others. Patents are territorial rights, which means that an invention is only protected in the countries or regions where patent protection has been obtained. In other words, if you have not been granted a patent with effect in a given country, your invention will not be protected in that country, enabling anybody else to make, use, import, or sell your invention in that country. I would like to mention one famous case which belongs to this Patent Act. You might have known this case. The Novartis versus Union of India in 2013, this case was a landmark judgment in Indian patent law that has had a profound impact on the interpretation and application of patentability criteria in the country. This legal battle centers around Novartis' patent application for the cancer drug Gleevec, composing the chemical substance imatinib mesylate, claiming that it was more effective in fighting leukemia and other cancers and has far-reaching implications for the pharmaceutical industry. The Supreme Court case hinged on the interpretation of Section 3D. The provision aims to prevent the practice of evergreening, where pharmaceutical companies make minor modifications to extend patent protection and maintain monopolies. The Supreme Court decided that the substance that Novartis sought to patent was indeed a modification of a known drug, the raw form of imatinib, which was publicly disclosed in the 1993 patent application and in scientific articles. That Novartis did not present evidence of a difference in therapeutic efficacy between the final form of Gleevec and the raw form of imatinib, and that therefore the patent application was properly rejected by the Patent Office and lower courts. The Novartis judgment has significant implications for the prevention of evergreening and the promotion of access to affordable medicines. It strikes a balance between protecting intellectual property rights and safeguarding public health interests. Now coming to the second part, trademarks. Trademarks, which is covered under Trademarks Act 1999. A trademark is a distinctive sign that identifies certain goods or services as those produced or provided by a specific person or enterprise. It may be one or a combination of words, letters, and numerals. They may consist of drawings, symbols, three-dimensional signs such as shape, packaging of goods, audible signs used as distinguishing features. It provides protection to the owner of the mark by ensuring the exclusive right to use it to identify goods or services or to authorize another to use it in return for payment. It helps consumers identify and purchase a product or service because of its nature and quality indicated by its unique trademark. Registration of trademark is prima facie proof of its ownership, giving statutory right to the proprietor. Trademark rights may be held in perpetuity. The initial term of registration is for 10 years. Thereafter, it may be renewed from time to time. The landmark judgment on this subject, Yahoo Inc. versus Akash Arora and another in 1999. The case relates to unauthorized registration and use of internet domain names that are similar and identical to registered trademarks and service marks, also known as cyber squatting. In this case, the defendant was using a domain name Yahoo India, which was extremely identical to that of the plaintiff's Yahoo. It was held that defendant's Yahoo India has the potential to confuse and deceive internet users into believing that both are the same and belong to the same Yahoo. The court explained that a disclaimer in this regard by the defendant to make people aware is not sufficient, and it is immaterial if the term Yahoo has a dictionary meaning. As over the years, Yahoo has already acquired distinctiveness and uniqueness as required under the trademark law. The High Court has also held that domain names on the internet are used by business groups for the same purpose as any trademark or service mark. There is also another case, Pfizer Productions Inc. versus Mr. Altamas Khan, 2006. The Delhi High Court held that cyber squatting is not permitted under the Trademarks Act 99. The court found that the defendant registered the domain name Viagra.in with the sole objective to sell it to interested parties on premium, which is not permissible. Now coming to the third part, Copyrights Act, which is covered under Copyrights Act 1957. Copyright is a legal right given to creators of literary, dramatic, musical and artistic works and producers of films and sound recordings. The kind of works covered by copyright include novels, poems, plays, reference works, newspapers and computer programs, databases, films, musical compositions, and choreography, paintings, drawings, photographs, sculptures, architecture, and advertisements, maps, technical drawings. Copyright subsists in a work by virtue of creation, hence it is not mandatory to register. However, certificate of registration of copyright serve as prima facie evidence in court of law. Creators often sell the rights of their works to individuals or companies best able to market the works in return for payment. The copyright term varies according to the nature of the work. 60 years from the death of the author in case of literary, dramatic, and musical artistic work, and 60 years after publication of a photograph, film, or sound recording. I am placing this case before you because I am my close association with Satsang. In copyright law, you will find thousands of cases, but I have chosen this case because of my close association with Satsang. There is a case in 1972, Satsang versus Kiran Chandra Mukhopadhyay and others. What happened in this case? A religious preacher, Sri Sri Anukul Chandra Chakravarti, better known to his followers as Sri Sri Anukul Thakur, wrote a Sat-anweshana in his own hand as early as 1910, recording some of his religious teachings and precepts which were published in book form the first time in 1919. In 1925, he founded a society of religious brotherhood of his followers called Satsang, which had a publishing unit known as Satsang Publishing House at Deoghar. The object of the society was to propagate the ideals of the Thakur. In due course, the society brought out 3 publications of his writings and discourses entitled Anushruti in 1949 and Alochana Prasange, 2 volumes in 1969. An exclusive license to publish his works was given by Sri Sri Thakur to his eldest son, Amrendra Nath Chakravarti, in 1957. Around 1970, 3 publications containing the writings and teachings of Thakur were brought out by 2 of his disciples, Kiran Chandra Mukhopadhyay and Kumud Bandhu Bal, which contained exclusive reproduction of preachers' writings and sermons taken from the works published by the Satsang. And noticing the same, the society filed a suit and applied for an interlocutory injunction against the defendants. The Honorable Calcutta High Court ruled that the writings and sermons of a religious preacher compiled on his behalf would come within the meaning of literary works and pass interlocutory injunction. Now coming to the fourth part, industrial design, which is covered under Designs Act 2000. Industrial designs refer to creative activity which result in the ornamental or formal appearance of a product, and design right refers to a novel or original design that is accorded to the proprietor of a validly registered design. Industrial designs are an element of intellectual property under the TRIPS agreement. Minimum standards of protection of industrial designs have been provided for. As a developing country, India has already amended its national legislation to provide for these minimal standards. The essential purpose of design law is to promote and protect the design element of industrial production. It is also intended to promote innovative activity in the field of industries. The existing legislation on industrial designs in India is contained in the new Designs Act 2000. And this will serve its purpose well in the rapid changes in technology and international developments. India has also achieved a mature status in the field of industrial designs And in view of globalization of the economy, the present legislation is aligned with the changed technical and commercial scenario and made to conform to international trends in design administration. This Replacement Act, because previously it was Indian Patents and Design Act 1911, and after that it was substituted by this Designs Act 2000, is also aimed to enact a more detailed classification of design to conform to the international system and to take care of the proliferation of design-related activities in various fields. And industrial design is registered for a period of 10 years and is extendable for another 5 years. There is a famous case which has a very great impact on this Design Act. Whirlpool of India Limited versus Videocon Industries Limited in 2014. This case was a watershed moment in Indian design law, addressing the issues of design infringement and passing off. The dispute revolved around the Pebble model. Pebble model is a semi-automatic washing machine introduced by Videocon Industries Limited that showed a remarkable resemblance to Whirlpool's registered design of its S model washing machine. Whirlpool sued Videocon, stating that Pebble's design was a forgery of its S washing machine, infringing on its registered designs and confusing customers. After reviewing the evidence, the Bombay High Court found that Videocon's Pebble washing machine did indeed infringe on Whirlpool's registered designs. The court found that the two washing machines had a strikingly similar general look, particularly in terms of the design and structure of the wash and spin areas. The court also determined that Videocon's objective was to capitalize on Whirlpool's goodwill and reputation by mimicking the design of its popular washing machine. Videocon's acts were considered to be passing off since consumers were likely to be deceived into thinking the Pebble washing machine was a Whirlpool product. The Bombay High Court issued a permanent injunction prohibiting Videocon from manufacturing, selling, or offering for the sale the Pebble washing machine in its decision. Whirlpool was granted damages for infringement of its copyrighted designs and passing off. The Whirlpool versus Videocon decision established a precedent in design law, highlighted the necessity of preserving original designs and avoiding unfair competition through design limitation. It also emphasized corporations exercising due diligence while designing products in order to avoid future infringement lawsuits. Now coming to the fifth part, geographical indications, which is covered under Geographical Indications of Goods Registration and Protection Act 1999. GI tags are signs used on goods that have a specific geographical origin and possess qualities or a reputation that are due to that place of origin. Agricultural products typically have qualities that derive from their place of production and are influenced by specific local factors such as climate and soil. They may also highlight specific qualities of a product which are due to human factors that can be found in the place of origin of the products, such as manufacturing skills and traditions. A geographical indication points to a specific place or origin of production that determines the characteristic qualities of the product that originates therein. It is important that the product derives its qualities and reputation from that place. Place of origin may be a village, a town, or a region or a country. It is an exclusive right given to a particular community, hence the benefits of its registration are shared by all the members of the community. The term of geographical indication protection is 10 years. In 2017, few years back, there was a fight we all know in social media and off it about the famous Rasagulla. I belong to Odisha and you people belong to West Bengal. We fought over this Rasagulla and this is coming under this GI tag. In 2017, West Bengal received GI tag for its variety of Rasagulla, which led many people believing that the sweet delicacy originated in West Bengal. This led to a fight between Odisha and West Bengal, both on social media and off it too. The tug of war between West Bengal and Odisha ended in a draw, with Odisha also being granted the GI tag for Odisha Rasagulla, that is less than 2 years after the West Bengal owned the GI tag for its Rasagulla. But the whole world knows that Rasagulla belongs to Bengal. West Bengal claimed that the idea of this delicacy was conceived by Nabin Chandra Das in 1968 at his Bagbazar residence in Kolkata. Odisha claimed that their Rasagulla dates back to the 12th century. During the festival of Niladri Bijay, Lord Jagannath offers Rasagulla to his disgruntled wife, goddess Lakshmi, on his return from a 9-day-long Rath Yatra. And there is mention of the word Rasagulla in the 15th century Odia Dandi Ramayana written by the medieval poet Balram Das. There are many other Odia and Sanskrit texts to prove that chena, as you call chana, or cottage cheese, was known to Indians much before Portuguese arrived in India. While there are multiple claims that the process of chana making was introduced first in Bengal by the Dutch colonists of Bandel in late 18th century. In its submission before the GI register, the Odisha Small Industries Corporation Limited, which has been awarded the GI tag, said Odisha Rasagulla is very soft to feel, juicy and non-chewy in consistency and can be swallowed without teeth pressure. The Rasagulla prepared in other places is circular in shape, milk white in color and basically spongy and chewy in consistency. Now coming to the sixth part, layout design for integrated circuits, which is covered under Semiconductor Integrated Circuits Layout Designs Act 2000. Semiconductor integrated circuit means a product having transistors and other circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform an electronic circuitry function. The Semiconductor Integrated Circuit Layout Design Act 2000 protects original inherently distinctive layout designs that have not been previously commercially exploited, and registration is a necessary prerequisite for protection. The main focus of SICLD Act is to provide for routes and mechanisms for protection of IPR in chip layout designs created and matters related to it. The SICLD Act empowers the registered proprietor of the layout design an inherent right to use the layout design, commercially exploit it, and obtain relief in respect of any infringement. The initial term of registration is for 10 years. Thereafter, it may be renewed from time to time. Ministry of Electronics and Information Technology is the administrative ministry looking after its registration and other matters. The day is not so far when India will become a global power in the manufacture of products for the semiconductor sector. Prime Minister Narendra Modi said on Wednesday, as he laid the foundation stone for 3 major semiconductor projects, 2 in Gujarat, 1 in Assam, valued at approximately 1.25 lakh crore. India is collaborating with US, Europe, UK, Japan, and Singapore to become a semiconductor manufacturing hub. Now coming to trade secrets. It may be confidential business information that provides an enterprise, a competitive edge may be considered a trade secret. Usually, these are manufacturing or industrial secrets and commercial secrets. These include sale methods, distribution methods, consumer profiles, advertising strategies, lists of suppliers and clients, and manufacturing processes. For example, the composition of Coca-Cola is a trade secret. Contrary to patents, trade secrets are protected without registration. A trade secret can be protected for an unlimited period of time, but a substantial element of secrecy must exist, so that, except by the use of improper means, there would be difficulty in acquiring the information. Considering the vast availability of traditional knowledge in the country, the protection under this will be very crucial in reaping benefits from such type of knowledge. The trade secret and traditional knowledge are also interlinked with the geographical indications. Now, protection of plants, varieties, and farmers' rights. The concepts of plant breeders' rights arises from the need to provide incentives to plant breeders engaged in the creative work of research which sustains agricultural progress through returns on the investments made in research, and to persuade the researcher to share the benefits of his creativity with society, with a view to provide for the establishment of an authority to give an effective system of protection of the rights of plant breeders and farmers, and to encourage the development of any new varieties of plants, and to give effect to the provisions of TRIPS agreement. The government enacted the Protection of Plant Varieties and Farmers' Rights Act 2001. This act seeks to stimulate investment for research and development both in public and private sectors for the development of new plant varieties by ensuring appropriate returns on such investments. It also seeks to facilitate the growth of the seed industry in the country through domestic and foreign investment to ensure the availability of high-quality seeds and planting material to Indian farmers. It also recognizes the role of farmers as cultivators and conservers, and the contribution of traditional, rural, and tribal communities to the country's agro-biodiversity by rewarding them for their contribution through benefit sharing and protecting the traditional rights of the farmers. Now, coming to the last part of intellectual property rights, that is biodiversity, which is covered under Biological Diversity Act 2002. In simple terms, biodiversity or diversity among various life forms within the biosphere refers to biodiversity. Biodiversity is the foundation of life on Earth. It is crucial for the functioning of ecosystems, which provides us with products, services without which we cannot live. By changing biodiversity, we strongly affect human well-being and the well-being of every other living creature. India is one of the 12 mega biodiversity countries of the world. With only 2.5% of the land area, India already accounts for 7 to 8% of recorded species of the world. Over 46,000 species of plants and 81,000 species of animals have been recorded in the country so far by the Botanical Survey of India and the Zoological Survey of India. In the Convention of Biological Diversity 1992, Rio de Janeiro, the member countries were pressurized to change their IPR laws to conform with the TRIPS agreement. India also followed the suit by placing in place legal frameworks for the management of biodiversity and intellectual property laws. Following India's ratification of the Convention on Biological Diversity, at international level, the Biological Diversity Act 2002 was adopted. The Biological Diversity Act aims at conservation of biological resources and associated knowledge, as well as facilitating access to them in a sustainable manner and equitable benefit sharing out of the utilization bioresources to the country and its people. 1995, two Indian nationalists, this is a case of biopiracy. What happened? In 1995, two Indian nationalists at the University of Mississippi Medical Center were granted US patent on the use of turmeric in wound healing. The Indian Council of Scientific and Industrial Research, that is CSIR, opposed this after its grant on the ground that use of turmeric for healing wounds and rashes has been in the public domain of traditional knowledge for thousands of years. Basing on the documentary evidence of Sanskrit text and a paper published in the Journal of Indian Medical Association 1953, the US Patent Office upheld the CSIR objection and revoked the patent. Now, I would like to conclude with these notes. Today, India is on its way to adopting a balanced approach towards creating a stimulus for the betterment of the IPR industry as a whole. Recent developments in India, be it in the new IPR policy or providing an effective toolkit in the form of checklist that will act as a reckoner for the police to deal with IP crimes, or encouragement to innovators in terms of speedy patent examination in case they file fast in India, all are part of much needed attempt to improve the overall security of IPR and encouragement to create more IP in the country, because the material-based society is changing into knowledge-based society. There are debates involving around whether artificial intelligence developers or users should hold intellectual property rights for artificial intelligence generated content. Existing laws allow only work created by human skills for copyright. Patent law only allows humans to be inventors. The law is silent and not clear about AI assisted or AI created work. India is having all the resources in terms of available raw material, cheap labor, innovative and creative dedicated manpower. No doubt, India will definitely harness its proportionate share in global trade by exploring in intellectual property rights and mark its footprint on international map as Creative India, Innovative India, Rachanatmak Bharat, Abhinav Bharat. Thank you. Thank you all. Mobile আপনার মোবাইলটা আছে খালি দেন একটু দেন এক মিনিট খালি I don't know how far you have understood my speech in very simple language. Lastly, I want to conclude. This mobile, every day we are using this mobile. The logo or the brand name is covered under trademark. The outer design shape is covered under Design Act. The Android system or operating system, that is covered under Copyright. And the technology, that is covered under Patents Act. Thank you.
I hope that all of you will have a productive day of interesting and stimulating discussion. If you have any question to ask, please ask our eminent speaker. Anyone from the audience, students? Anyone?
Everyone has understood whatever I said. That is my credibility.
Thank you, sir. Thank you for such a thorough. Oh, okay. Sir, one person is there. Sir, kindly say your name.
So first of all, Jai Guru and good morning to everyone. So I'm from here, right on your left. Sir?
Yes, please.
Sir, I have a question. As a layman, like, can I like patent a jewelry design, and if I can, if somebody steals or sorry, not steal, uses the design and sell
Jewelry design is coming under Design Act.
design act. Yes, sir.
Design.
And if somebody
You can register that design, any kind of design that is having commercial value.
okay. And if somebody uses it and earns commercial benefit from it, and so which authority should I go to claim my rights?
The design office is in Kolkata.
Okay.
You have the design office in Kolkata.
Okay. Okay. Thank you, sir.
Thank
It
you.
was great to hear from you, sir.
Okay.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you, everyone. Thank you.
Jai Guru. Now we are going to call upon the stage an immense personality who teaches at the West Bengal National University of Juridical Science, which we call NUJS. He is also the director of the Center for Study and Research on Consumer Law. He has qualified for the National Eligibility Test, NET, for lecturership conducted by the University Grant Commission. The UGC has also awarded him a Junior Research Fellowship. He also received the Gopal Subramaniam Scholarship for his outstanding performance in the Master of Law. He teaches criminal law, consumer law, and forensic science. Besides, he imparts training to professionals on various aspects of law. The trainee includes members of the bar and the bench, police officers, members of the consumer commissions, registers, corporate professionals, and paralegal volunteers. He has published papers in internationally and nationally reputed journals on several themes, including the applications of cognitive psychology and criminal law, anti-conversion law, relevance of expert opinion in sexual offenses, matrimonial offenses, data protection, and Islamic banking. He has presented several papers at international and national conferences. He has delivered hundreds of talks as a resource person in seminars and workshops on various issues related to criminal law and consumer rights. It is my privilege to call upon the stage Mr. Dr. Faisal Fasi from NUJS. Please give a round of applause for him. Yes.
No, can you put that?
Deepa Acharya Ma, I invite you on the dais to please hand over the memento to Mr. Dr. Faisal Faizi.
Connection.
लगा रहे
ঠিক আছে এখন চালিয়ে একটু দেখে নিন ঠিক আছে এটা কানেক্ট হয়ে গেছে
ओकन
দেওয়া আছে তো কানেকশন হ্যাঁ উনি দিয়ে রেখেছে আর একটা ওকে এই তো স্ক্রিন নিয়েছে কানেকশন নিয়েছে
हो जाएगा हो जाएगा
যখন স্ক্রিনে ফিট করে দিন আপনি শুরু করুন, ফিট করে দিন।
Sujo. Okay. Fine.
হ্যাঁ ঠিক আছে।
Amita, can I start? But it, let it another visible, right? So what to do? Can you do it? There's some arrangement is done. Okay. No, if it is visible, they can read it fine. I don't need. I can manage. If it can be adjusted for the participant, then it's fine. I don't need to see that. Okay. Can we start? All right. Very good morning to everyone out here. Right at the outset, I would like to thank the organizer for conducting this wonderful workshop. So, little bit of hesitancy, hiccup. Then we are starting after a very, very comprehensive lecture on intellectual property rights. So it's time for change. We are going to discuss for the next couple of sessions about criminal law. So the first session we have started from the substantive law, and the analysis is about a law which was in force for around 164 years, precisely 162 years, from 1862, though the act was enacted in 1860. I'm talking about Indian Penal Code. So when the Indian Penal Code was framed, it was the first law commission which was set up in the country in the 1830s, and from that time they started writing the penal code. Basically, the Britishers started writing penal code for us, and it got into force in 1862. So that particular law was still in force just a couple of months back, till 30th June. So the government has presented that it is high time to do away from the colonial hangover, from the colonial legacy, and law should be in tune with the values and ethos of our culture and the contemporary times. So that is the message which is given by the government. So the discussion which is happening, and we are part of a lot of discussion on these new laws, there are a lot of discussion regarding the policy consideration, that where we are heading. Are we really contemporary? Is it a progressive law? It is something which is regressive in nature. Is it an overhauling of the criminal law? So these are some of the fundamental questions which have been raised by people. So the one way of looking at this particular law is that we can go for the critical analysis of the law from the perspective of policy. Having said that, law can be good or bad. The changes can be substantive, cosmetic, but law is law. So the focus of the discussion, since this is a very small session of around half an hour, it's not going a detailed analysis of the policy consideration. Rather than, I'll focus on what the law is and what could be the possible interpretation and where we are exactly moving, rather than, just questioning the law, because now the law is in force. So the portion which I am going to discuss is about the substantive aspect of criminal law. And apart from this, you are aware of that there are two other acts, that is Criminal Procedure Code and Indian Evidence Act, also got repealed. So we have completely new set of criminal law, at least by name. So we have, in place of Indian Penal Code, we have Bharatiya Nyaya Sanhita, BNS. In place of CRPC, that is Code of Criminal Procedure, we have BNSS, Bharatiya Nagrik Suraksha Sanhita. Then we have, in the place of Indian Evidence Act, that is Bharatiya Sakshya Adhiniyam. So these are the three laws. So I'll be covering the first one, which is about the offense and punishment. Now, before I come to the main theme, the impression given by the government, and that is the general consensus among people, that there are a lot of changes, hundreds of changes done by the government, and it is something which is a completely new law. So right at the outset, I would like to say that, see, it is not completely new. In fact, I don't find a single provision of this particular law which is new for me. Why I'm saying so? Because all the changes which they have done, even if we go with the substantive changes, the thing which is completely new, which has been introduced first time in the substantive criminal law, that is the general law of the land, it has been borrowed from some special law, local law, or from the guidelines of the court. So if we track the sources of the changes, there are primarily three sources. Number one, the law which was a part of special law, confined for a special procedure, that has become the general law of the land. For example, something like introduction of Terrorist Act under 113 of BNS. So it was already there under UAPA, Unlawful Atrocities Prevention Act. That thing has been incorporated in the general law. So this is source number one. Source number two, the law which had a territorial application, which is technically called local law. So territorial application means the application is confined to a particular state. That has become the national legislation. The best example for me is Maharashtra Organized Crime Control Act, which was in 1999. Inspired by Maharashtra, other states took up that. Similar kind of legislation they came up. But in Bengal, we never had anything called Organized Crime Control Act. Now, since it's a national legislation, so in Bengal also Organized Crime Control Act become a new offense. So this is category number two. And last but definitely not the least, the developments which have happened in the court, especially the apex court of the country, where the courts have given guidelines from time to time that you find has been incorporated in the laws. Again, the example if I have to pick, then it should be none other than where a very important social message has been given, that is a case of mob lynching. So these are the three fundamental sources of the new law which we are going to study. Why I'm making out this particular point? For the time being, till the time the proper interpretation is not coming, so if we are interested to know that what is the meaning of a particular law which is completely new under BNS, so we have to go to the source. So we have to go to the guideline of the court, we have to go to the interpretation under special law. So that's a simple understanding of it. Let's come to the point. So this particular slide is a very, very comprehensive slide in the sense it covers all the substantive changes under BNS, that is Bharatiya Nyaya Sanhita. Now, to study this, what I have done, I have divided the entire subject into two broad categories. That is the two subject matter of, it was the subject matter of Indian Penal Code, same we have written in Bharatiya Nyaya Sanhita, that is BNS. So when we think of substantive criminal law, it deals with two subjects. One is what is crime or what is offense, and if a person has committed offense, what should be the punishment. So crime and punishment, or offense or punishment, these are the two broad subject matter of criminal law. So accordingly, I have divided this this into this two broad theme. So there are changes in offense and there are changes in punishment. So of course the major changes are in offense, and that is what we are interested to know. So but I'll start with punishment first because we can cover it in just a couple of minutes. So in punishment, it can be further classified into two categories. One is the introduction of new punishment which was not there in the Indian jurisprudence, and second is about the changes in punishment and the quantum of punishment. So from the perspective of quantum of punishment, there are quite a few changes. It's more than 100 changes. There are around 83 provisions where the amount of fine has been increased. So according to the present scenario, there are around 30 provisions where the actual quantum of punishment has increased, say from 5 years to 10 years. But the third category is very important, and that is the most important for me. There are around 23 provisions in the new law where there is a mandatory minimum punishment. Now, what exactly is mandatory minimum punishment? We know when you read criminal law, it is generally about up to 10 years, up to 5 years. But in handful of cases, you have minimum punishment. That means the court cannot give less than minimum unless there is a very, very special reason to do that. Now, one of the major changes in punishment is there are as many as 23 provisions where the mandatory minimum punishment has been incorporated. So this is from the punishment side. The introduction of new categories of punishment, that is the sixth category. We have 5 categories: death sentence, 2 types of imprisonment, fine. Now we have 6th category, that is community service. Now for us, this is something new. This came into force only a couple of months back. But elsewhere in the world, it was in practice, not only for last couple of decades, it was in practice for, few decades back. So even if we take the example of the island close to us, that is Sri Lanka. So even they were practicing community service, it was a part of their laws from 1980s. So we are slightly late in this. So what is the idea behind this? That if a person is involved in a petty crime, a small crime, then that person should not be mixed with the hardcore criminal, and prison system should not be overburdened. Therefore, community service should be given. That is a kind of reformation. That is about something which kind of a lesson to the person that this kind of activity should not be done. However, the word community service is not defined. So only one reference we find, that is from the procedural law, BNSS, where they said anything which benefits the public. That's it. So it is open for interpretation. Now the judges and the court will take a call that what exactly is community service and what is not. But there are 6 categories of offenses where community service has been included. So this is from the side of the punishment, that the quantum has increased, new punishment has come up. So this is done from the side of punishment. Now let's look at the main topic of the day. That is about what are the offenses and new crimes which have come up. It is not only important for the students of law. I can see mostly I can see students of law, but even for general people from the layman's perspective, it is very, very important to know, as we are aware of being a student of law, that ignorance of law is not an excuse. That means even if I do an act, and if my act comes within the letter of the law, irrespective of ignorance, I may be charged for it. So that shows the importance of this particular discussion. So when we look from the offense perspective, I have classified into 3 categories. The new offenses which have come in, 1. Second is about modification done in the old offenses, lot of modification done. And third is about certain offenses are removed and it has been deleted permanently. So we'll study this into 3 different things. We'll start with what are the addition, what are the new things that they have done. So I'll be going very systematically. I'll be dividing it into topic wise. So this is the first topic where major change has been done, that is offenses against human body. So there are precisely 4 offenses against human body. That is a new introduction. So I'll just take up one by one. The first is definitely a case of mob lynching. This particular thing was not expressly written in any letter of the law, though there were guidelines of the Supreme Court. Like one case, if you can read, I know it's not visible, that is Tehsin Poonawalla versus Union of India. This is a case where the Supreme Court gave a comprehensive guideline and explained the social condition of the country, that what is happening at the present moment, that is definitely not the rule of law. So I'll come to rule of law in a moment, but let's understand what this offense is about. Mob lynching is a very simple crime. When a murder is committed by 5 or more people, and the motivation for committing murder, one of the grounds which they have mentioned, that is technically called mob lynching. So a simple example could be, say, on the ground of personal belief, somebody is having a particular belief, and that is something, a motivation for other group of people or for a group of people to kill that person. If that is done, a simple case of mob lynching. Similarly, say somebody belongs to a particular community, somebody carries a particular caste identity, somebody is having a particular language. So if this is the ground to kill a human being, and if 5 people are involved, that is technically called mob lynching. Now the very first thing to note here, which is not confined only to mob lynching, but that is the general understanding of this law, and this is also very important for the students of law to understand how to read this law. The red mark, if you can see from the back, so the right side extreme right, I have marked it in red, that any other ground. So whenever you come across something which is any other ground, that's an indication that this is not a comprehensive provision. That means this is inclusive in nature. You can add similar kind of thing which is over here. Now this discussion is very, very crucial, because what you can see over here, there are only 6 grounds, but there can be another 600 types of cases in real life which may not literally fit in this particular 6 ground. For example, how about a case of, say, honor killing? Say a person is killed because that person mingled with someone and the family member killed that person and 5 people are involved. So expressly honor killing is not here. But when we go with the extension of all this thing, and if we apply a Constitution of India, which prohibits discrimination of any type, so it is very easy to fit something like honor killing by virtue of any other ground. Similarly, a person, you are aware of the disturbing trend in the country, and this is something which we have to advertise, we have to create awareness among the people. Thankfully, West Bengal is much, much better, and I don't mind saying in public, when we compare on this particular aspect, a state like Uttar Pradesh. So where a person consumes a particular thing, that can be a ground of mob lynching. When a person professes a particular work, that can be a ground of mob lynching. There cannot be anything more inhuman than, I'm consuming something and that is the reason that a person will kill me. So for me, it is something very, very serious. So what is the message behind this? The message is that, there should not be any kind of killing, there should not be any kind of injury, because somebody is having a particular ascribed identity. I have a particular identity. Because of that, if you charge me, that is something definitely against the rule of law. So what is the message over here when we read about crime? So a very mechanical understanding of crime is that a particular act is wrong, this person has committed crime, he should be penalized. There is a slogan which is humming for the last 1 month in Bengal, we want justice. Right? That is the slogan going on. So we want justice is about not just about hanging that particular person, but hanging the accused is not justice. So all these people are there, investigation is going on, but people are not happy because this is not justice. So what exactly is this idea of justice when we are connecting with, say, a criminal law? This is a very good provision to connect and understand about justice, that when punishment is given, there's a different aspect that this particular person will not commit crime, others should also be deterred from that particular aspect. But when you look in a broader context, which is the essence of criminal law, that there should be a message whenever the judgment or order is given if anybody contravenes criminal law. There should be some social message. Now, it's a very simple way of saying that if a person is killed, that's a simple case of murder. But the moment you say that this person is killed because he was having a particular identity, so this is something very disturbing, and there should be a very, very clear social message that this is a civilized nation. We are a nation where we are bound by constitution, we are bound by rule of law. So nobody should be above the law. That means, irrespective of the scenario, even I have done something illegal, the person should not take the law in the hand, and due process of law should be followed, then only something should happen. Now imagine a case, this RG case is one of the most disturbing cases which we'll come across in our life. Now if due process is not followed and this person is lynched to death, whether it will be justice, the answer is no. So the message which is given over here, there's a very important social message. The protection of the identity, 1. Second, the due process of law should be followed, even if the person is doing an illegal act. That is the reason this is one of the best amendments done in the light of the contemporary times. Moving on. Now come to the second offense. So mob lynching came from the Supreme Court, lot of petition before the court. This time we have an offense which is coming from the special law. So the first state in the country is Maharashtra. They came up with Organized Crime Control Act. What exactly is this? This particular is a strict law against an habitual offender. So the law separates someone who is a first-time offender and someone who is a habitual offender. The requirement of the law, these are the precise 4 requirements. I'm not carrying the bare act over here. So what is the nature of the offense here? That if a person is involved in continuous illegal or unlawful activity. The definition of unlawful activity is that there's a group of people, against them there's 2 charge sheets, and the court have taken cognizance of the 2 charge sheets. The decision has not been taken. Third time they have also committed that particular wrong. Now this time the law is very, very strict that if you do it third time where 2 charge sheet is already there, then the law will be harsh and more punishment will be given. That will be called organized crime. That means, say I commit an act, if you look at the list, so this is again not a comprehensive definition, kidnapping, robbery, extortion. Say I am charged for extortion, say last year, I was also charged for extortion, say 2 years back. Now, third time, if I am charged for extortion, it will not be a normal case of extortion where 3 years, 5 years punishment will happen. It will be an organized crime where the punishment can even go to death sentence if somebody dies. So this is a very good move again, I'll say, where, the hardcore criminal and habitual offender will be under scanner, and it's high time that we should, try to implement this. But there's something interesting about this particular offense, which is there are a couple of unique things which were not there in the law before. What we understand about when the group is involved, so there are 2 kinds of liability happens. The liability will be joint or vicarious. Say group of people, 5 of us, if we go and commit the crime, irrespective of the contribution, the liability of all will be same. Okay? This much was there, but the interesting thing they have added, said we are a group of people, we are not going to commit crime, we hire someone who is not a part of the group. That person has committed the wrong, he will be definitely charged, but along with that, we all 5 will be charged. That is the new introduction. It was not there in the IPC. That is an extension of vicarious liability. The message over here is the act of the agent is the act of the principal. So that has been incorporated here. Now, what is this offense about? And what is the focus of the offense? That is the last thing. That is the purpose of the offense. The purpose of the offense is financial gain. That means all this a person will do to get some kind of illegal benefit, which is technically called wrongful gain. That means the focus over here is not human body. It is the unlawful gain, that is property. But the interesting part, if you remember what I said 5 minutes back, and I hope you are following it, that this comes under offenses against human body. But this is a property offense. The focus is property. Anyways, so this is one point. The second interesting part about this particular offense, which is not interesting, in fact, this is going to open a Pandora box. So I have again marked a particular thing in a red, that is the word prepare. This I have simply taken from the definition. These are the 10 categories of people who can be charged for organized crime. The 9 category, leaving the red one, if you can see, then all these are common form of liability which was already there in Indian Penal Code. Preparation generally is not a ground for liability except 2 situations. If I prepare to commit a wrong, which is against the state, which is a waging war against the state, 1, and second is preparation to commit dacoity. So these are the only two exceptions where preparation can be a ground of liability. Now we have a third category, organized crime, where mere preparation is a crime in itself. Now the question is, what is there to worry about it? Because there's something serious, and at the stage of preparation, there should be check. The problem is the moment, see, there are 2 aspects of this particular law, and especially the new law. One is the theoretical understanding of the law, and second is when you are understanding the law in the real life, that is about the practical aspect of the law. So if I use a very simple sentence, there is a clear case of mismatch between the theory and the practice. What is that mismatch? The theoretical definition of preparation, if you go through, I'll not go in definition and all, so you'll find that there's a certain requirement, but when you apply this, now imagine a case, I belong to a group where there is an allegation against our group that we have committed 2 crimes which have not yet been proved. That means 2 charge sheets have been submitted. And after that, police raid my home and they have recovered, say, illegal gun from my home, which is a wrong, definitely an illegal act under Arms Act. Now, an interpretation can go that maybe I have acquired all this weapon to commit third crime, and therefore I should be charged for organized crime. That means it has opened the Pandora box, and it depends about what kind of interpretation is going to come up. If the interpretation is very, very strict, then it may create trouble for a lot of people. But if the court is act very maturely rather than mechanically, then it may try to balance it. So only time will tell us. Okay. So this is not a brother of organized crime. This time the amendment they have done, they have not followed the old system. The old system is that always there's a base form of offense and then there's an aggravated form. Say hurt, grievous hurt, culpable homicide, murder, this was the pattern. Now this pattern is not followed. So prima facie it seemed that something like petty organized crime is connected with organized crime, but there's no connection whatsoever. But for me, this is very important offense. In fact, this is the best for me. If I have to pick one offense from it, I'll pick petty organized crime. The reason for picking this, for the contemporary development and what is happening around, for me, one of the most disturbing thing happening around, which is covered first time in the law under petty organized crime. And it's not written here, like the entire section, but I tell you, one of the ground of petty organized crime is they have come up with a new idea, which is called trick theft, T-R-I-C-K, trick theft. So this particular thing was not a part of the Indian law. It was a part of foreign jurisdiction. Now, what compelled the legislature to come up? Trick theft simply means that any kind of theft where the person has used some kind of trick to manipulate or extract money, property from someone. Now, if I take a call from audience, which obviously I'll not take, so if I ask that what is the best trick which is happening where everybody is a potential victim, or maybe some of us are the victim of that, then it has to be a case of scam, cybercrime. So just for a change, I remember 4 or 5 years back, a police officer called me and he was asking me that, see, a person has given OTP and he's such a learned person, so he's talking about the stupidity of that person, that how come somebody can give OTP. This is just a few years back, 5 years back, before COVID. And he was asking me that what could be the possible provision of law which can be applied for this kind of cybercrime. It was new 5 years back. So I told him that this provision, but he was very critical of that how can someone such a learned person, mature person can share OTP with a random person. I said something which was a very niche code which happened that time, sabka number aayega. So when I say sabka number aayega, you can connect that there is a place in Jharkhand very close to Bengal, maybe 300 kilometers from here, which is not notorious only in the country, but is notorious in the world. That is Jamtara. So there are a lot of popular media culture on that. Jamtara is a place you will not find. I have not extensively traveled, but I've traveled most part of the country, most state. I have not seen any place like Jamtara, and I don't think you will come across one. Jamtara is a place where you'll find that, it's a row of huts, like people are very poor, basically. And education level is very, very low. So almost everyone is a school dropout. Now suddenly you realize that there's a row of hut, 4 or 5, and all of a sudden a bungalow pop up. That bungalow you will not find in Calcutta or Bombay. So you will wonder who is this person that suddenly there's a bungalow over here. So this trend continues. Every 10, 20 huts, suddenly you realize that is a bungalow pop up. Now this owner of this bungalow is a juvenile. Juvenile means the person who is below 18 years. 3 days back, a juvenile, he is known to me. His age is 15 years. He celebrated his birthday of 15th year. He's just touching 16. This boy said that, see, I'm very worried because I have committed a wrong. So it's a kind of confession he was making. I said, what happened? Tell me anything serious. He said that, see, I have taken money from people. I said, okay, so what's the big deal? Return it. So don't waste time. So I took it very casually. No, it's not possible to return. I said, with whom you have taken? He said, I don't know with whom I have taken. I said, how much amount? He said, I can't calculate. I said, it must be 10,000, 20,000. What's the big deal? Forget about 1,000. Think about crores. This 15-year-old is having a savings of more than 50 crores. And all this is scam. So this is a very good introduction where they have highlighted the concept like trick theft, and that is petty organized crime. The sad part of this amendment is done in hurry, it seems. There is not even a smell of human body here. So one may wonder what this offense is doing under human body. Because this is all about property. So this is a shorty piece of amendment when we cover this. So there's nothing related to human body, but this is under human body. Okay. I'm slightly fast because there are a lot of things to discuss, but I can understand the other speaker also. Now we come to the serious one, and the last one in the human body. The moment we think of terrorists, so in the morning I thought I'll carry some images and all, but then I did not get time. The moment we think of terrorism, terrorist, what comes in our mind are something like 26/11 will come for most of us, that Mumbai attack. Something like Parliament attack will come. That is all about terrorism. So the general consensus is that when we say terrorism, it is the most heinous crime, there's no doubt about it, in the country, and the punishment is obviously death sentence, the highest punishment which is awarded. But when you look at the letter of the law, this is the letter of the law, not today. It was always there in UAPA since 1967. What is the letter of the law? I have just covered the major portion over here. The highlighted one, you said, anyone who is likely to threaten or anyone who is likely to cause injury. That means to become a terrorist in the country, you don't have to kill anyone, you don't have to cause injury to anyone, but there's a threat from you that you may cause injury and you may kill someone, so you may be branded as terrorist. Now the question is, what is the difference between something as serious as branding someone as terrorist with someone who wants to just cause injury to someone? So the catch over here is, this injury is not the focus. The focus over here is that the act should not be against the sovereignty and unity of the nation. So the focus over here is it should not go against the constitutional values and against the state. So any act which is likely to cause, which will go against the sovereignty or unity of the nation, then that person may be branded as terrorist, where their sentence can be given. So this is something very, very serious, but ironically, the injury death is not required. So again, this is, a lot of people are saying this is a very problematic thing, because in the general law of the land, and anyone who is likely to cause injury, that particular case can be prosecuted by the police officer, otherwise it is done by special agency, so that is a matter of concern. However, I repeat again what I said, that this amendment is not a good piece of amendment. Now, nobody can explain how come something like terrorist act comes under offense against human body. It can't be, impossible. When we say terrorism, Parliament attack, Mumbai attack, it's not about against an individual. It should be against the state, but this is, for some reason, under human body. The last slide for human body, this is the slide which you should be interested in, because this slide and this categories of people, we are perhaps the only country in the world where the liability can go on to 16 categories of people. There is no other provision anywhere in the world where 16 types of people can be held responsible for a crime. Now, what is the essence of this and what is the disturbing part of this particular thing? There are certain grounds for liability for terrorism where death sentence can be given. Those are generic idea, not legal term. So if I pick word from here, say something like attempt, commit, conspiracy, these are technical terms having a proper meaning. But when you pick something from here about, say, advise. Now, if I advise someone, there's a possibility that I may be branded as a terrorist. So if I float an idea right now, this is a big forum, that, this discussion is fine, law has been changed. How about exploring the option of joining some international group, say maybe ISIS? And say one of you, inspired by me, I just floated this idea, like, let's check what is going on in ISIS. And if someone joins it, don't you think that they can, at least they can initiate an action against me, that I advise people that why not explore ISIS? That may be sufficient to give death sentence. I'm not going into real cases, but there is a political thing involved here. So it's not just a legal amendment. So this is about human body. There are a lot of things, but since it's a general forum, so better to avoid. Anyways, moving on to property. I have only one slide for property, and this is the only slide. So if you are interested to know about property offense, everything is there in this slide, but I know it's not visible from the back. So the idea of property offense for the student of law, if you are interested to read property offense, never ever read in isolation, because the offenses are interconnected. The base offense is always theft, and from theft, a lot of offenses happen. So what are the changes which have taken place in the property offense? The changes is also in the offense of theft, because that is the base offense. So earlier, when we think of theft, the theft was not of what was discussed in the previous lecture about intellectual property. That was not the subject matter of IPC. IPC theft was always tangible, corporeal. Something which we can see, touch, hear, that was the subject matter of theft. That means it should be movable property which is tangible, corporeal in nature. Now what they have done, they have removed this word corporeal and they have said any property. Now, you will realize suddenly there are more cases of theft coming up because the horizon has been broadened. So tomorrow if again this controversy of Rasagulla comes between Odisha and Bengal, chances are BNS will be attached with intellect GI, so that we have to see that how they are going to apply. So this is one change, interesting change which has happened. The other thing which was very, very important, which was required, for some reason it was not there for the past 2 centuries, that is the case of snatching, which is very common. So this is something which we all know is a clear wrong, but there was not dedicated provision was not there. Now we have come up with a dedicated provision in section 303 of BNS, which is theft by snatching. What it simply means, when the theft is committed, there is something sudden jerk or movement to take the property. That means a simple case, say I'm talking about mobile, somebody comes and snatch, and there are different kinds of that the way the people snatch. So it's like all funny that when I was traveling in Delhi, I was inside an auto. So this is a few years back. So I was talking over the phone. The auto driver said that please shift and come in middle. I was alone. I said why? I just it's fine. You ride. So I'll sit in this side. No, please come. I said, tell me what is the reason. He said that the phone over which you are talking, chances it will not be in your hand, in the running auto. I said, what? And the auto is at the speed of 50. He said that, see, it happens regularly. So those are cases of snatching. That means the idea is whenever offender and victim comes in a physical contact, most of the cases of theft will become a case of snatching. So we have now 2 categories of theft, where somebody enters your house without your permission, consent, takes something, a normal case of theft. But the moment there is a victim and offender comes together, that may be a case of snatching. So that is a very good introduction, very good move. And regarding stolen property, that is the third major change and the last change in property. Stolen property is something which if I possess, if I deal, if I transfer, then my liability is as good as I have committed the wrong. So one subject matter was not there in stolen property, cheating was not there. So anything which is acquired from cheating, that was not the subject matter of stolen property. Now they have added the word cheating in the definition of stolen property. That means property which is acquired from cheating, if that property is in the possession of someone, that person will also be liable in law. A very, very important move and a very welcome move, because we are aware of that in all these cases of scams, the money come out from the house of the driver or from the head, but not from the ministers. So this is something, a very good introduction whenever cheating case takes place. Okay, now coming to the moral side of this amendment. That was hardcore criminal law, and I was reading this, now that display is not there, that there should be a moral content to the law. So initial lecture was very interesting for me because I was reading all this, so this display has changed, that there should be a moral element of law. I request everyone that this is something which you should give time, few seconds, and this particular section will explain the moral content of the law and where we are heading, what is our right, and exactly what the law today is from the moral perspective. So if you look at this particular provision, this was new, this was not there, section 69. There are 2 subject matters here. One is there is a case of false promise to marry, and the person obtains consent from a woman, have sexual intercourse, and after that, this person dishes the woman and is not willing to marry. So it was always there, it was a crime, this section was not there, but it was a case of cheating clubbed with rape. So there was no problem, second category. But I'm interested to discuss the first category. So the first category is deceitful means. If you can't see, then I can tell you, the first one is deceitful means. So anyone through deceitful means obtain consent, commit the act of sexual intercourse with a woman, that will be a crime under section 69, where the punishment can go up to 10 years. Wonderful. So far there is no problem, and this is a very, very welcome move, that if there is a deceitful means, that's a case of absence of consent. Now when you look at the explanation says that deceitful means shall include, against the inclusive provision. It's about false promise of employment, promotion, inducement. So just be confined to 2 words, employment and promotion. So imagine a case where the employer says to an employee is a female, this is a gender specific provision, not gender neutral, where the employer says that I'll give you a promotion provided you give up your chastity, dignity, honor, and you will be promoted from assistant manager to manager. So after making this promise, if the promise is not fulfilled, the employee can file a case against the employer that this person has obtained consent, sexually, this person has committed sexual intercourse, and therefore he should be charged under 69. Makes sense, because this is a false promise. Now, the thing which I am speaking for the last 6 months in the public forum, like I'm not boasting, but quoted by all the leading newspaper and media of the country on this point, and I'm slightly surprised that people are having debate on this. So what I said that, does it matter whether it is false promise or true promise? Even if the promise is fulfilled, don't you think there's a moral element first, then I'll come to legal element. So if the employers give the benefit to the employee who is a lady, maybe employment or promotion. Now I can see a lot of women here, and because of that, the woman has to give her dignity, honor, chastity, and promotion, employment is given. Is this justified? This is fine? Not, right? But when you listen to this particular subject from stalwart, from the scholars, and the people who are involved in changing this particular law. So I had an opportunity to interact with a lot of people connected with Ministry of Law and Justice. They are saying that this is a very, very regressive provision. This should not fit in criminal law at all. You are saying that this true promise should also be included. They are saying that even false promise should not be included. So these are all subject matter of civil law. Are you living in the age of 18th century? You are talking about crime for this? So we have a complete two extreme. One extreme is, like people like me, I'll give my opinion. I'll go against the provision, and I'm saying for me it doesn't matter whether it is false or true promise, because purchasing the dignity or honor of a woman, irrespective of the benefit, that should not be tolerated in this particular society. Because we know that we live in a society where people are vulnerable. So over here, the household maid come in our houses, even they get 100 rupees per day for cleaning the utensils. That is the life we have. So imagine a case on a particular day, a household maid looking for a job where the return will be 100 rupees. And this man is saying, I'll give you a job to clean my utensils, to my clothes, and for that you have to give your dignity, honor, and everything. This woman, vulnerable, may be willing to purchase medicine, and if she actually consents, this is perfectly fine according to letter of the law. So for me, this is the most disturbing provision, but subject to, I don't mind taking up other perspective, but this should go. Okay, now there's a protection for children. It was there, but now we have a proper category, that is section 95, where any kind of exploitation to the children should be taken very seriously. This provision was not there. This is again a very, very good introduction. It was there, but it was not very categorically mentioned in IPC. We know that the children have, they are employed to become beggar and for other kind of things. So all these cases will come under 95. Okay, last provision for the change, like all the major change. And this provision where we should be most careful among all the provision. This is 152. When this law was advertised, or when the first time this law was discussed in the parliament, the Union Minister Amit Shah made one particular point where he was emphasizing that it is high time we should do away with something like sedition 124A. Because sedition is something which, if you go back to the days of NRC, where students were arrested, beaten up in Delhi and a lot of other places, so those are something which should not be tolerated. Okay, so organizers are very thankful even to think about water, but anyways, I'll take it. Thank you. So this particular law was advertised, and Amit Shah said that, see, the first thing we should get away is 124A, because sedition is something which should not be done. And people should have right to criticize the policy of the government, and we live in democracy, free speech and all that. So 124A they have removed. But what they have done is they have added new section, 152. It was not there. So I have just marked one in red. I don't know whether it is visible. I have marked one word here. That word is subversive. So since I don't have time to go through entire section, if you open any dictionary in the world, if you go through any interpretation, the first synonyms of subversive will be sedition, if that is a proper dictionary. So just one category, this subversive is nothing but it is sedition. There are a lot of other things which can become subversive activity. There are other aspects, so the opinion and kind of consensus there in the country that this is an aggravated form of sedition. And this is just like sedition has been repacked and it has been made aggravated. Now, why this is a matter of concern for us? This is a matter of concern for us because there was a time, just a couple of decades back, that only a handful of people in the country were a public speaker, and we used to communicate in public. And otherwise, we were all used to communicate in private. But nowadays, there are a handful of people who are not public speaker or who is not communicating in the public. I'm picking up social media. So when you are interacting in social media, when you are interacting in public, when you are speaking in this kind of forum, you should be very, very careful, because if you say something which can hit the, gray area of the government, which is a criticism of the government, chances are they may prosecute you under 152. Now, acquittal conviction is later on. That is something separate. I'll share one case, and that should explain, this is important for public awareness. We should know that. That person is still alive. He was a journalist in Kashmir. This is 2009. All these laws were not there. His name is Iftikhar Jilani. What happened is, he used to write in his newspaper one column. So he wrote something in the paper, and he was charged under Official Secrets Act. That time, all these laws were not there. So he said, what wrong I have committed? So he said that you have written against the government, this is sedition, and will prosecute you under this special law. Now, the problem with all this special law, even access to lawyer is not given. So this man was behind the bar for 9 months, and for the first time he appeared in the court of law after 9 months. So he said that what wrong I have committed. The court said that you are charged for this wrong under Official Secrets Act, which is a serious, heinous crime. So he said, tell me what exactly you have done. So the court said that, see, the prosecution has presented, you have written this in your media, and therefore this is a clear case of against the government. This man said that you have access to internet, you type this, what I have written, you'll find thousands of documents well before 2009. So it was already there in public domain, the entire country knew that. I just lifted from there and copy-pasted that. So it is not my creation. Then the court said this is a wrong prosecution, that how come that person should be arrested for this, the state should compensate. 9 months gone. So the reason I am highlighting this, that please be careful when you are interacting in public, and you should be very, very precise when you are writing, that even a word can be taken very seriously. The prosecution has already started. Some of the people who have written in social media, even against RG case, 1 or 2, not charged sheet, FIR has been recorded. Anyways. Okay, so there are a lot of other provisions, but I'll not go in small provisions. So this is a very interesting provision, and it was required that even if somebody abates to commit crime in the country, outside the country, he will be liable as if he has committed the crime in country. That means, say, a person in Pakistan trying to abate to commit crime in India. So if he ever comes to India, anyhow, this person will be arrested, and by virtue of 48, he will be treated as if he has committed crime in the country. I'm wrapping it up. I know this is a long lecture. So this is another thing, a small offense where somebody compelling public servant that you do this act, otherwise I'll commit suicide. Not very important, so I'll skip this. Okay, last slide, and this is the end. So far what we have done is about the inclusion of the offense. That new thing has been added. There is a positive side of it when we think from mob lynching. There is a problem side of it when we think of something like terrorism under this law. There is a problem side of it when we look at 152. But now certain things they have removed. And as I said before, that this piece of amendment, for some reason, it was a hasty thing done. Proper consultation, maybe they have not applied mind properly. I don't mind saying in public. So the thing which has been excluded, I'm leaving the first one, and I'm speaking about rest of the other thing. So what they have done, they have removed something which was already declared unconstitutional by the court. For example, 497, adultery. Something like, sedition is now gone. Thug, outdated. That is again about targeting a particular community, basically ST. So these are good things they have done. Something which was covered in the special law, like false weight and measure, we have a law called Legal Metrology Act 2009. So it is covered there. So duplication they have avoided. So all these are fine. But when we focus on the first thing, and if I ask a question right now, you will be in trouble, because we don't have a clear answer. We know that there was a case of Navteej Johar in the Supreme Court, where the Supreme Court said that this right, LGBT rights, they have recognized this as a fundamental right, that there is nothing wrong, it is nothing unnatural, so we'll not go in debate of that. So the court said that this is Victorian morality incorporated by the Britishers, so we are making it unconstitutional. So section 377 gone. For the consensual act, that means in section 377 there were two types of cases, consensual and non-consensual. Now the question is, what if today there is a non-consensual case among the same sex? What to do? That means we are aware of that there are predators available and roaming around in this society where, say, if a person exploits a child, say, child is covered up to 18 years, POXO Act is there. So say one person commits an act with the same gender, a male or female, gay or lesbianism, then what will happen? Now we don't have a law. 377 is gone. That means we don't have a law at all. Now, a small provision, if there's an injury, that is injury, but that is not about, charge for the wrong which the person has committed. So this is something which is a major gap. It's amazing how come, they can come up with a law where they have removed something which is very, very important. And I tell you why this is very important. During COVID time, we organized a conference. And the reason for organizing that conference, where the students came in contact with one professor of the US, she has expertise in necrophilia. Necrophilia, sex with the dead body. Okay? So this person, the student, they wrote to me that, sir, there is a professor who is having expertise in necrophilia, so we want to organize a talk on that. I said, you've gone mad or what? COVID time, you want to discuss on necrophilia. So this is like madness. And nobody will come and listen to you, even online. Okay? But I said, okay, go ahead. Obviously, like COVID time, I was not there. So go ahead means they have organized that particular discussion on necrophilia. It was one of the most popular workshops we have ever done. So many people wrote to me that it was a wonderful discussion. So I was wondering that the content was good, but how come so many people in the world is interested about necrophilia? That why people commit sex with the dead body. So the argument is we don't have a clear provision. The reason why I'm saying is that people are interested to know that people are committing even, heinous act, immoral act, now it's obviously illegal act, like sexual intercourse with a dead body. So if this is a society, and we don't have 377, which covers LGBTQ+, which covers necrophilia, which covers carnal intercourse with animal, there are cases of bestiality in the country. So the question is where we are moving. So one way of looking is that this is a very progressive law, recognition of individual autonomy. So when we say individual autonomy, one of the broadest definition of individual autonomy is I can do whatever I feel till the time I am not disturbing others. This is the idea of right. This is the broadest, most liberal definition. But we are aware of, when we think of human rights, fundamental rights, it cannot be absolute in nature, right? Just merely I'm not disturbing others, that should not be a reason to justify every possible act. So looking from the side of individual autonomy, those who are championing this particular thing, a progressive law. But when we look from the moral perspective, when you look from the societal perspective, when you look from the social fabric, there are a lot of disturbing things in the law. So only time will tell us where we are heading. It's too early to take a call. So whether it is going to help in the path of administration of justice, or it is just a sheer case of missed opportunity that is not going to happen for another maybe couple of centuries. So thank you very much for your patient listening. I was very, very happy. Wonderful discussion. Now we can take questions. Yes, sir. Yes, sir. Well, okay. Thank you, sir. Very good question and very important, especially in the context of what is happening in Ajika case. There's a precise case on the point. That is 2009 decision of Selvi versus State of Karnataka, where this point was taken up by the Supreme Court exactly on this particular point. The law is clearly, and it is a settled law. In fact, last week I was discussing this in the class. So the law says, when we go through Selvi versus State of Karnataka, they have gone for this scientific as well as legal analysis of this, lie detector, narco test and all that. The finding of the court, in the light of the expert opinion which came, that scientifically it is not a proper test. There are a lot of limitations of the test. So this was the scientific part. Then the legal part, they have gone through the interpretation of the article of the Constitution, and there were consensus among the judges that, see, this is a violation of the fundamental right, starting from violation of right to privacy to freedom and Article 21 settled. However, what the court has done, court has said that if the subject is willing to consent, that means the person is willing to consent, then the authority can conduct lie detector narco test. However, this finding of the narco test is not an evidence. This can be used for the purpose of investigation. So, no sir, you are a senior person, that it is as good as nothing more than 27. This statement given under 27. Having said this, what is happening in the country, and like we'll not pick RG Kakel again and again, we know that there are cases where narco and lie detector tests are being conducted, and we are not sure of whether the accused has given consent. So it's a settled position of the law. Going with Selvi versus State of Karnataka, not permitted unless the consent is given. Yeah. Yes. I think we...
Sir, my question is that if any evidence provided by way of manipulating digital footprint, can Bharatiya Nyaya Sanhita has provided any specification or provided any specific section under the new law?
No, see, evidence, this BNS is not about evidence. BNS, so evidence I'll cover. So your precise question is that evidence has been, you can come that evidence portion again?
If any evidence provided by way of manipulating digital
Yes.
footprint.
Okay. Okay, I'll just speak for maybe a minute on this, but this is a very, very good question and very important question, though it is not connected with BNS. But that's okay. This is precisely a question of a BSA, Bharatiya Sakshi Adhinayam, read in light of the Constitution. Now, this is very important for the student of law who are present here. What we know, see, again, I'll reiterate what I said, that law is not about, it's not a mechanical subject. So the moment you read the rule that X, Y, Z, this is the law, that is mainly about memory, okay? So what memory says, every letter of the law, every word of the law, of the statute should be subjected to the constitution of the country. Fundamental right, precisely. Anything which is in contravention of the fundamental right, that is illegal, unconstitutional. Settled position, okay? So this is again, this fundamental concept for me is also a matter of memory. It's a theory. Now I tell you a scenario. Scenario is, say I carry a hidden camera. I have done a sting operation. I have collected evidence. I presented that in the court of law. The court will verify, expert will verify, tampered, no tampered. Whether any court in the world will say that we will not accept that. Whether any court is having the audacity to say that. We are aware of that there are cases of sting operation. A big company has been shattered, cases like Tehalka. The present government was almost gone because of one case, right? So we are familiar like what happened during the time of election. So this particular topic is very important for me because there was a Malimat committee which was set up in 2003 and there are a lot of other reports. Please note this, evidence is evidence. Evidence is evidence. How I have collected that. Now there's a big concept, poisonous tree concept and all, I'll not go. Evidence is evidence. Say I enter your house, I've committed theft of the document, which is the original document which talks about rights and liabilities. Since I enter your house, I'll be charged for trespass. I've committed theft, you can charge me for theft. But if I produce that in the court will not say that this is duplicate document. Because the document, it speaks for itself. So this relevance of this particular question is that when evidence is not collected in a legal manner, what will happen to that? So the general answer which I have given, evidence is evidence if it is logically and reasonably, if it is proper. So I hope that answered the question, that this power of evidence law. So we always say in the class that this is one subject where you should not go with memory. Practically it is possible that there can be a scenario, even overriding the fundamental right, they can present the evidence. I hope that answered part of your question. Yeah. Yes.
Good morning, sir. Sir, I'm Ronak Mondal. Sir, my question is related to the fact that as we know that in BNS there is a provision related to the economic offense. So, sir, as we know that with the emergence of digital currencies like cryptocurrency, there has been a rise in the economic offenses like various frauds and this sort of stuff. Sir, so like does BNS covers this provision related to economic offense through digital currency, sir?
Very, very good question. And this is what we love, that there should be a contemporaneous aspect in the question. Well, the old people maybe will not connect with bitcoins, but this is what we love. That thank you very much for raising this particular point. See, as I said that in a way this is a very progressive law when you think from the societal perspective. Now this term cybercrime, first time has come in the general law of the land. So when we say cybercrime, we always think of a special law, IT Act and all. But when you read organized crime, petty organized crime, with all this inclusive definition, expressly they have mentioned cybercrime. So I don't have time to go through provision again, but yes, if there is any kind of irregularity, wrongful gain, wrongful loss, it is broad enough, and it's a deliberate plan that they have kept it inclusive to cover something like, completely online thing that is something as simple as Bitcoin. So cybercrime is one of the addition, and this is one of the objective of this present law, where the government said that it's also about curbing the emerging crimes, and they have given example of cybercrime. But yes, it is included, provided subject to interpretation. So we don't have a case, proper case, because it's only 2 months. But it's there. Like as an organized crime, petty organized crime, yes. Yeah.
So thank you for your amazing lecture on the changes incorporated in the BNS. But my question is regarding a recent proposal that has been made on a bill, that is the Aparajita bill, and specifically there is this one section that attracts my attention, that is section 21, that talks about an overriding effect. It states that this law aims at being an addition to, or as well as it is not inconsistent with any other law. But certainly it also states that if it is inconsistent with any other law, then this law will be having an overriding effect. As per the constitution, is there any kind of...
Very good question. I must thank the organizer that, calling this kind of participant, because these are some of the fundamental questions and very important for all of us. So it's time for take a little bit of footage for me. I'm one of the person who contributed in this bill. So Sujo is there, he has also written. So we have contributed in the sense that we have given our recommendation. Some of the thing is included in this particular bill, but I have not given this recommendation. One aspect I wrote about the heinous case of death sentence in cases like Ajikar. So that is the part of Aparajita bill. Now this is a very important provision, not only for Aparajita, but this is a standard provision in any special law, you'll find. So I'll just speak for 30 seconds, the background of the, not this, just the principle. See, when an event takes place, there's always a possibility, I'm talking about 100% case where more than one law will apply. Okay? Now the categories of law, I've already mentioned 3 categories, 3 broad categories. General law of the land, for example, BNS or IPC. A special law, for example, Arms Act. Local law, for example, West Bengal Tenancy Act. Okay? So we have 3 categories. Now, it is possible that one particular act is covered under all 3 laws. Then what to do? The settled position of law, according to the guideline of the court, according to rule of interpretation, according to parliament, according to settled position, that the best approach is to go for harmonious interpretation of multiple laws. Settled. Like no confusion on this. However, if harmony is not possible for some reason, then a special law overrides the general law. This is the precise point. That means there is a conflict. Say a person is found with an Arms Act plus IPC. This is the approach. Because now the court will take a call which one is better for promoting justice. So the standard pattern, the court will say that this man should be convicted under Arms Act or IPC, read with Arms Act, or Arms Act read with IPC. Settled position. In case of conflict, where this harmony is not happening, a special law will override. Now the reason why they give this particular thing, they say that this is an act which is in addition to, not in derogation of the existing law. That means there is an existing law in place. Now we have BNS. So this Aparajita bill is in addition to BNS. It is not something which is against BNS. So this is the theory. But when it comes to the matter, when it comes to court, say this bill becomes the law tomorrow. And if there is a case on the Aparajita bill, the court will club Aparajita bill with BNS and will give harmonious interpretation. But there is a possibility that what is covered in Aparajita bill, that is not there in BNS. Then Aparajita bill will override BNS. That is the explanation they have given. And just to add more to this, where we are comparing special law with the general law, it's not about 2 legislation. It can be about 2 provision also. So when you think of BNS, IPC, we have a standard definition of consent, which is in IPC section 90, and we have a definition of consent in Sexual Act also. So if there is a Sexual Act, the definition which is given in 375 of IPC, I'm referring to IPC because I think most of you are familiar with that. So that is the definition of consent, not the general definition of consent, because 375 consent is special law comparing to section 90 general law. The rules of electronic evidence is a special law comparing to rules of document is a general law. So this is the idea which is incorporated. Why I'm picking up section 69? I'm picking up section 69 not from the moral point of view. My argument over here is that there is a case of power imbalance between employer and employee. the law is very clear. When there's an undue influence, power imbalance, there's a presumption of absence of consent. So we always start with the presumption of absence of consent. Now the law says that even if there's a presumption of absence of consent, even there's a case of undue influence, mainly the person has promised, fulfilled the promise, maybe for say 100 rupees, 1000 rupees, whatever, then it is no crime. That is the problem. So I hope that clarifies the point. Yeah. I think somebody from there.
A very good morning, sir, and a very good morning, everyone. My name is Lakshman Shah, and I am the student of the Calcutta University. My question is, what were the motivation behind the replacement of IPC, Indian Penal Code, with the BNS, Bharatiya Nyaya Sahita? And another question is, impact on victim and accused. Does the BNS propose reform to make the criminal justice system more accessible to the common people or common citizens?
Okay, thank you very much. Okay, in the beginning I said the objective, but I'll just categorize that. See, the government has given the objective that they have said that the law, IPC basically, it's a very old law. It's an archaic law, and it contains a lot of dated provision, and it carries the colonial hangover. It was a Britishers-made law. It was incorporation of Victorian morality. So these are the reasons that it's time to do away with the colonial hangover, and we should have an Indianized version of criminal law. Okay. Second reason they have said that there are a lot of emerging crimes which are not covered because back then all the cyber crime and things were not there. So to tackle with the emerging crimes. So these are the two major reasons the new law BNS has come into force. Okay. Now coming to your second question. So victim rights is a matter of procedure. It's not a substantive thing. It is not covered under BNS. So it will be covered under BNSS, Bharatiya Nagrik Suraksha Sanhita. So there we have a scheme, and I'm sure after this session, Sujo will take up on that. And the focus, one of the focus of the discussion will be victim right. So better I don't trespass in his, in his domain. So the changes have happened, and definitely if you compare with the old law, today we are better placed from 1st July when you think about protection of victim or for the protection of witness. So we never had a dedicated provision on the protection of witness. Now we have a specific provision 398 of BNSS where the witness protection scheme was mentioned, and it is up to the state to come up. So giving a broad answer to your question, because it requires a detailed discussion, that yes, we have protection from 1st July. We are much, much better than what we were in 30th June. And the reason I have mentioned that. Okay?
Thank you very much, sir.
I don't have any issue. So I think we should end it here. Thank you very much. It was a wonderful discussion, and I enjoyed all the questions.
Thank you so much, sir, for your inspirational speeches.
আমরা সবাই বাঙালি তো?
May I now invite Mr. Bivas Chatterjee, Public Prosecutor relating cyber law and electronic evidence, Government of West Bengal. He will deliver his lecture or the speech, you can say, on cyber laws and AI.
Before Mr. Chatterjee begins, please, we are really happy and obliged for the august presence of our chief guest, former acting Chief Justice of Calcutta High Court and sitting Justice Mr. Apurva Singh Rai. Now, I think the session will continue in English only. And we are now facilitating Mr. Chatterjee with a memento, showing our gratitude for making time for this seminar. We know he is very busy, and just after concluding, he is going to attend one trial. So please pay attention.
So the journey started, I think, in the year 2009-10.
I was told to appoint, or sorry, I was told to be, lead a case where there was a lot of state was there within the jurisdiction of that case, because we know for cybercrime investigation or trial or any crime related to the virtual world, there is no limitations or specific jurisdiction. That's why, you know, even that to be included with the 173 of new BNSS, zero FIR after the Verma committees and all these issues are there. But the main point was that in the year 2009 and 10, I just fell in love with this subject. And I made an 11 days journey to Odisha, and there was a multi-state involvement crime. Renowned telecom company's website was defaced. And the technology on that phase of time and technology of 2024, in terms of investigation and trial, it's changed hugely, because we have BNSS, we have BNS, we have BNA, all has the most important, the majority of amendment or changes, I should say, is in terms of inclusion of electronic evidence into the entire judicial system. Actually, what I am doing, or I have been doing since 2009 or 10, so at the beginning, when I used to visit different seminars and keep telling with more jealousness and other things, that see, there will be days when there will be nothing except the digital evidence. See, things has come to and knocking our door. Everywhere. You see, recently there was a case the accused persons all been awarded life imprisonment. I think you all followed that in Barakpur. Bluetooth data was very important and instrumental in establishing the guilt of the accused person. So what they did, they left at the time of, after commission of crime, the heinous murder with Jakrati, they left there one of the pair of their Bluetooth in the PO. So our investigating agency, the commissioner of Barakpur, they collected, they thereafter seized the mobile phone of one of the offender when he was arrested from Bihar. And when the mobile phone and the Bluetooth was sent to the forensic expert department, they told that this mobile was paired with this Bluetooth. So this is one of the example I am giving, a lot of experiment, because I am thankful to the government of West Bengal, because in 2012 the government of West Bengal has thought that there should be a public prosecutor who is going to work on the field of cyber and electronic evidences. And I'm working still 2012 and 13 odd, and we are standing on 2024. Not that huge success that we achieved in terms of ultimately getting the conviction to the well-medited case, heinous case and all this. Odd 57 cases I have been able to complete it, and out of that 56 cases has seen the result of conviction. One case I have lost, and I have written a letter to the LR, and the appeal has been admitted. There's a very heinous murder case, lot of electronic evidence was involved into it. Later than lot of cases, what I believe is, what I am doing, and I'll expect you all do, is to make an experiment, because it's a very new field. We are not USA or UK, where the things are already developed. See, Aklo versus Renault is one of the landmark judgment. When in USA, there are a lot of concepts coming into it, child pornography, what is the definition of internet, all important things. Because see, in present law, if you read minutely section 57 of BNA, you will have a very interesting definitions of what is primary evidence. And within that, there are 4 explanation clauses, which says what is the primary evidence in terms of dealing with electronic evidence. Now, when we are in the cybercrime or anything like that, our most important criteria, definitely conventional evidence and non-conventional evidence will go hands in hand. Definitely we have to take both of them. One thing is not complete, but as because India is world's second largest internet user, and will in the front runner in competing and beating China, I think within 2 or 3 years from now. So as because India is the second largest internet user, people are at least nearing 100 crores Indians are all the time logged into or glued into either in WhatsApp or in Facebook or in any other online or OTTP mode or any virtual platforms. So from that perspective, the evidence are on the virtual world. I believe it. I used to believe it and still believing it, and until my death I will be going to believe the same. Because everything what we are doing, one part of the same is there, the sitting there, because as per I am a strong believer of local exchange principle. So whenever a criminal or an offender is committing a crime, he or she is leaving something in the system and taking something from the system. This is not in respect of a normal murder, rape and other crime. This is also in respect of the toughest cyber crimes which is committed in throughout the world. See, we know if I am told to commit a crime, I'll definitely, as a certified ethical hacker, I'll try to change my actual IP to someone's IP. I'm going to change my MAC address to someone's other's MAC address, and then I will enter into, means I'll make myself anonymous, right? And then I'm going to commit the crime. So the same way the criminals are thinking. So in any type of crime, whatever toughest it may be for an investigating agency to crack, there is always a hope. We are thinking, I'm telling it hope, because the last part of a certified ethical hacker, we are taught that covering the track you are following, say for example, I have to kill a person sitting in this auditorium or hall, and I will not be, because strategy will take entry through any of the windows or any of the gates or anything. So I may be a rose, apparently, but I may be a metasploit. So a single liner metasploit is enough to crack the bank account of an corrupted politician, right? So we are on that world. So I'm a strong believer of, actually we have a law called Whistleblower Protection Act. I think you all heard about that act. It's a fantastic act. One of the young man working in the banking field, he was just frustrated of how even after the different, some influential persons' accounts were termed as NPA, even the loan amount was disbursed to those persons making some dubious activities and other. What he did, he hacked the system of that bank, and then after getting all these data, send it to the CVC, the Central Vigilance Commission and other. So one of that offender, he was used to be seated in the highest post of that bank, made a complaint to a concerned officer, police station, and the police station, on tracing on the IP and other thing, called that person, the parents of that person. I got a call at 10 o'clock in the night. And the officer, when I requested the officer what you are doing, he told, see, he has done such a huge crime, has hacked the system of the bank and all this. I say, what he did is absolutely lawful. And if you do not do the law, follow the law, then something will come which may be severe to you. So I referred the Whistleblower Protection Act. So as a young man, all you are sitting, cyber world is giving a huge opportunity to work in any field. And I'm not telling about that I am sitting on 25th December 2023. I am sitting thereafter, all three bills has come into effect. Application has started from 1st of July. And believe me, the most interesting changes in our criminal law, and definitely the civil law is going to take place of it, because in 1999 the British had amended their civil law. We are yet to be on that mode. But it will be definitely having, because the Evidence Act, because the Evidence Act has been totally changed to BNA, then we will have the entire scope of application of electronic evidence or digital evidence or any kind of cyber crimes and related thing. Now, when we are talking about these entire phases, because I think my learned brothers are there sitting here. So coming to the very raw issue, that things started in India taking a shape since Parliament Attack case. In Parliament Attack case, the question was that whether that intercepted data or any other type of data, because after the explosion in the Parliament, there was a intercepted data coming into the people who have committed the crime. They are talking to each other, and their data and other things, data from the nodal of the telecom company, these are all been put into the trial. And the question was raised that why not Section 65B was been followed, because the point was there, previously, say for example, 25, 30 years ago, the the world judiciary, say UK, USA and other developed countries, they were thinking of that electronic evidence is susceptible to change, prone to change, very futile and should not be relied upon. That was a concept I am telling about 25, 30 years previously. But today it is no longer, because we think that is our destiny. We have to follow, we have to collect, we have to put, we have to execute our cases in terms of the electronic evidence and digital evidence. And my dear friends, the world of cyber, the virtual world, and any crime committed on the virtual world will be arrested, will be taken care of if we can collect our electronic evidence. Our officers who are investigating, our lawyers are actually, they are the half. I do believe, I'm a strong believer of my Lord Arun Mistra's judgment, that a public prosecutor even can come with any evidence and not confined within the four corners of the case diary. Believe me, most of all of the cases that I have delayed 50% of the investigation done by the investigating agency, and the 50% investigation did by myself at the time of trial. Lot of evidences I called for, they have later been proved very crucial. Because if we again rely on the Locard exchange principles, age back, Edmond Locard was used to call a Sherlock Holmes of France. He was given a small room and he was working on that area. And he came up with a very fantastic interpretation. That is, there is always a scope of the evidence is lying for us. We have to collect it, and evidence is always there. It is our inability that we cannot collect, we cannot catch, and we can produce the same in the right way, in the right point of time. So in doing so, the crime which is happening in the cyber world, when a machine or a man is a target, is called cybercrime. There's a lot of definitions. The word been coined or termed differently by different agencies. But what I believe, any crime committed through or by way of the virtual world is cybercrime. So it can be a virtual crime, it can be a cybercrime. Our law presently, I must say, Information Technology Act, we have 94, there are some repealment there, odd 92 sections, provisions are there, but that is not enough. People are, young brothers are keep telling me, how can we start doing work in this field? I always prescribe you, don't confine yourself within the four corners of the law book. Go and read the technology, because I have completed within my span of these 23 years of practice 11 certification internationally on different fields related to cloud and other things. I have done my AI certification in 2019, and presently in 2024 I have done my AI. Sea change means within a field I have to refresh, I have to upgrade myself, and you yourself have to upgrade into it. I am telling you, you simply fell in love with this subject. This is my concept. I have filled it because there's a lot of things to do. And young mind, you all are busy with the mobile phone. You are using mobile phone. You are using the data. You are seeing that how the data can be taken. See, from year 9, say for example, 25, 20, 30 years previously, I am telling people used to say, we cannot rely on electronic evidence. In our present scenario, in Parliament at a case, we only think about that electronic evidence is always a secondary evidence. We don't think of that it can be given in a situation, in a specific circumstances, it can be treated as a primary evidence. We first saw the concept in Arjun Pandit Rao judgment, and previously that Basir judgment. So when if I take your 5 minutes from your time, the see is that the evolution and the revolution of how to deal with electronic evidence. 3 or 4 important judgments which played a very important role in Indian judicial history. First was the Parliament at a case which says, if 65B is not been compiled with, then the investigation of the trial is not fatal, because the clause in 65A said, maybe the content of an electronic record may be proved as provided in 65B. So there was a term called, phrase called maybe, and now the fight become, what is the interpretation of the phrase maybe? Because law is not the law you go and purchase and start reading a book of law. Law is the interpretation of law, what I understood in my 23 years of journeys as a lawyer. So law is the interpretation of the law. See how the term maybe has been interpreted since 2000, Parliament at a case. In Basir judgment, after 9 years, the Honorable Supreme Court, larger banks came with an interpretation that maybe should be interpreted as must be. And without 65B, electronic evidence is inadmissible and it's a mandatory precondition. Same Honorable Supreme Court, one bench larger, stated that it's a mandatory precondition. Then there was a problem started because in a lot of cases were there where the 65B compliance was not made, but there are hugely crucial electronic evidences involved. Then came in 2019 the Arjun Karnataka Lokayuk judgment. It says 65B non-compliance is not fatal. It can be complied at any point of time. So we gave some laxity or relaxation into the procedural law. How can electronic evidence be made or given a status of a primary evidence? In between time, in 2018, we have a very renowned judgment called the Safi Muhammad. In Safi Muhammad, the Honorable Supreme Court says, okay, if the evidence is otherwise relevant and if the evidence is a very crucial one, then that be the fact because it's the 65B compliance, means the compliance of admissibility, non-admissibility is not been followed properly, then it is not that evidence has to be simply thrown away to the dustbin. And going one step further, the Safi Muhammad judgment says that if I do not have the device, I don't have any compulsion to provide any statement under section 65B. That was a contrary views given by Bashir and Safi, and both of them sent to the larger judge, and we came with the 2020 the Arjun Pandit Rao judgment. And shortly speaking, it's Arjun Pandit Rao judgment. Fantastic interpretation, three-liner interpretation. It's a huge judgment. You can read it with it. We have tried to import the worldwide concept in two very important judgments in my field. You should read. One is the Arjun Pandit Rao judgment and Shreya Singhal judgment. Both have elaborately accepted and imported different interpretations given in worldwide in different judiciaries worldwide. Say Nigeria, Argentina, say USA, UK, and even from South Africa. We have borrowed the concept and we have come with this thing. See, the very important and crucial concept, even the how to prove the admissibility or how to present the electronic evidence to prove a cyber crime is also raised upon the most important evidence act that's called Federal Rule of Evidence, that is the evidence law of USA. There's a different article. We have almost make a copy paste of the article 10337 and all other things and put it into our statement in proving the admissibility. So whenever you are having a time to venture out more on this subject, please read the Federal Rule of Evidence. They have worked a lot. They have worked on screenshot. They have worked on hearsay evidence. They made research on that poem maybe 10 or 15 years prior to us. So if you go on those things, you will get a gist of, because our law has been made by the British, but the law I am telling today is being actually framed by the USA, not by the UK. So you can go and read all these things. Now what I am telling, that in Arjun Pandit Rao judgment, we have been faced with two important questions. What will be then concept of admissibility of electronic evidence? Now the Arjun Pandit Rao has come with a very three-liner simple interpretation. Number one, I am giving a simple example. This is my mobile phone. So I have a habit of making a video because I think my profession, exclusively my way of working, is nothing but a legal tourism. Because I keep visiting. Last 13 days, I was visiting entire Bengal. I think you all heard about the Matikara, the death sentence was awarded against that convict. And starting from that, Malda, from Siliguri, I keep visiting entire Bengal. So whenever I get an opportunity, I pick up my mobile phone and started making some video and all this. Say, for example, I was coming to Mohajati Southern. And in coming to Mohajati Southern, I was making some video of a very nice place or any other things, which is striking to me. And when I was doing it, there was some conflict between two persons. There was some maramari and hatahati and all this. Then one person suddenly picking out a knife and stabbed the other person. A murder has been committed. Say, for example, tomorrow, an investigating officer knocked my door stating that, Mr. Chatterjee, we have information that there was a murder being committed, a case has been initiated, and you were there and captured the entire thing in your mobile phone. And it is the first time capture in your mobile phone. So could you provide us the evidence to us so that we can crack the criminal and get the justice? Or confirm the justice? Or do something for the justice to be confirmed? So in that, because today the most important word in Google is "we want justice" and Archikar. If you go and search by anything, we'll get the search engine optimization will come with the word Archikar and "we want justice." Because the most penetrating world is not your road and physical world. The most penetrating world is the virtual world. So a person standing on Jantar Mantar or anything, or brigade or anything, stating day and night something of his thinking and other things, and the same thing. Maybe 100 or 200 or 300 people are going to watch and hear what he is actually stating. But if you've been posted on virtual world, within a minute, it can penetrate to the bedroom of millions of persons. That's why it has got a very huge penetrating power in this virtual world. And because of this mobile phone, and because of the development of the cloud computing technology, the smartphone become the most powerful instrument in the world. Because every time, my mobile cannot catch that amount of data. But my mobile phone is always connected with the cloud, which is a storehouse of huge data. It's such a huge, even you cannot imagine. When we were taught by, when I was doing my Microsoft Certified Professionalism in Big Data, we are told that we are taught with a research paper that the data we have we are having since first day of civilization till 2015-16 is only the 2% of the data, what amount of data we have dealt with since 2017 to 2022, as doing it in the year 2022. You can understand the concept of big data, such a huge data, and every time you are clicking into it, your big data is your bedroom. So that's the reason the internet with the standalone device had made this evolution and this revolution. And today we are thinking of, if you come to the BNS, we have interesting areas that extortion can be through e-world. Say for example, we have children in our houses, we have family members of our houses, they have a very interesting habit of making reels, videos and everything. Say for example, my son was making reels for the last 5 or 3 months on his own subject. He was actually pursuing psychology and other things. So making YouTube videos and his concept sharing and all these things. So his voice, his way of speaking, his nodding of head, everything is with the machine. And gesture, posture, everything. So if a script been put into it, taking all this video into a AI app, then the app, it was in 2018 or 19, when I was first pursuing my AI certification, I was told, or we are making a research on this paper, then we have some amount of data, we'll create a model with them, and then we test other portion of the data with the model. Say for example, I'll ask the machine whether this is a cat or a leopard or anything else. The machine will precisely tell, yes, this is not a cat, but this is a leopard. How can this be possible? Because previously I fed billions of data into the AI, and now the AI is ready to differentiate between a cat and a leopard. So today we are no longer on that. We are much, much higher. We are now in a neural learning. Say we have imported the concept of the Almighty, how the Almighty made our brain. So our brain is made of billions of neurons. And in neural networking, the similar concept is been evolved into. And this neural networking is now is aware of what you are thinking, what you are doing, what is your mindset, what you want, what you do not want. Say, I'm giving a very example of a very interesting case. There's a two contrary case come into play. One was in favor, another was against. So a lady in USA, it was a minor girl, and there was a lot of messages, promotional videos, everything was coming to that lady. The content of that promotion was that the material containing newborn babies, a diaper, baby foods and all these things. The parents got those videos because spam is taken very seriously in US and other developed countries. They have taken this very seriously. They filed a complaint against those companies. Why you are sending this type of promotional spam messages and videos and everything to my minor daughter who had not been married till date, and these are relates to our newly born baby and other things. So when the things went up to the forum, it was it's a very peculiar thing, very interesting thing is that it was later found that that girl, 17 years girl, was 1 month pregnant. And it was not known to the parents of that lady. It was known to whom? The Google. It was known to whom? Who deals with the data. It was known to whom? Who works on your data. Who are called the data brokers. And these people, when you are making a post, when you are liking a post, when you are making a comment in your post, whatever you are doing in your virtual world, they just keeping your data intact in the big server and then analyzing it, data analyzing. So they are making an analysis of the data and making a perfect picture of what you are. So that is what you heard about in Cambridge Analytica. Another part, they can even change the political view of the people. You are set to vote a particular political party tomorrow. Today something will happen. Your entire narrative, your mindset will going to change. Later on, after giving the vote, you will understand or realize that it was a fake news. So this world is such a penetrating world. It can create havoc. It can do a good thing as well, and drastically bad thing as well. So thing is that we have to be aware. The simple thing is the awareness, and that's why different seminars are going on and things are going on. The last thing what I was telling you, my friend was standing. Last thing was I want to tell in Arjun Pandit Rao judgment. So I have a habit of making videos in my mobile phone. So the investigating officer came to my house, knocking the door. Please, Mr. Chatterjee, provide me with the videos. I told him, okay, this is my mobile phone, and I am giving this mobile phone to you. So it was a mobile which first time captured the data of the murder scene. So the Honorable Supreme Court says, in Arjun Pandit Rao judgment, that it can be given a status of a primary evidence or original evidence. No law stated in India prior to Arjun Pandit Rao judgment that even electronic evidence can be given that amount of status. So, two important things. I can tell my learned, officers, see, this I cannot give you the mobile phone because I can give you the video because it has been cracked and it's been destroyed. And what is going to happen? On the next day, I can say, okay, before doing it, I send it to one of my friends to WhatsApp, and you can go and collect the same. And this evidence, with respect to me when it's first time captured, is a primary evidence. And the other part, when I send to my friend from where the evidence is collected, it is secondary evidence with respect to this. So that concept has been inbuilt in section 57 of India, our BNA, and it says that primary evidence, when it is captured in a simultaneous process, in a same process, in a same way simultaneously, then all the devices which captured the same data to be taken or given a primary evidence status. It has given a huge relaxation or laxity to all the judicial stakeholders in India, because otherwise, taking an electronic evidence, because it is not the evidence which is important in our field, it is how we collect, how we preserve, and how we present the same before court of law or any forum on which the justice will be awarded is the most important thing. Thank you. Anything else?
Thank you. In the field of the cyber law, Mr. VIDHI Chatterjee, one of the eminent speakers, having prudent knowledge in West Bengal, is public prosecutor of government of West Bengal, is delivered the speech, and students have every questions to the teacher, to the speaker. Please put your questions.
Anybody? Please.
Good afternoon, sir.
Good afternoon, madam.
Sir, my pronouns are he and she. You are mistaken with the pronoun. My pronouns are he and him.
Okay.
Now, my question is that, so imagine a situation when a person wants to commit a crime.
Yes.
Now, what he does, he uses artificial intelligence chatbot, AI chatbot, to search how he should commit the crime. Like the planning he gets from AI chatbot. Now, can that be used as an evidence in the court, that chat history?
Yes, madam. We have previously Section 8.
Sir, you are again mistaken with the pronoun.
Oh, sorry, man. Sorry. Brother, the point is that previously we had Section 8 and other things. We have new laws on that front. The conduct and the process the criminals were doing prior commission of crime is a very important evidence in our judicial system. So we can take the entire conspiracy, the entire process of making the AI and other things into our things, evidence, and that is a very vital evidence. Because I think you all heard about one of my murder case where after commission of the crime, the offender being a lady, the wife, he was searching the Google on ligature material. So the ligature material here was the cord of the charger of an iPhone. So the activity in the Google search engine, we have taken that search engine and put it in a court to prove, the conduct of the criminal prior and after and at the time of commission of crime. So fantastic evidence, we need this. Now the problem with us is that how our officers, how they are developed to take this challenge of how we can collect this evidence. Again, I am telling how we collect this evidence, because the massacre has been made. What I've seen in my experiment with this subject, the massacre has been made in collection itself of evidence, because electronic evidence is very sensitive to handle. So how the things will be collected, because you can have a seminar, you can have a lot of expert in different fields, but I am telling you a very simple thing. And I keep visiting in different seminars, but nowadays I don't get the time. The most important thing is not the theory. The most important thing is the application. When you want to put this sophisticated concept into any remotest part of our Bengal or part of India, you will feel the heat. Because a lot of the places are there when the things are even you can. Yesterday I was conducting a trial. If I don't get a device to run a gate pattern video in a forum. So this is the situation or scenario. So one practical application is 1,000 theory. So I'll request you all, don't engross yourself reading only theory. Go and make experiment and read at least those experimented cases. Because when you put your knowledge into real field, things are completely different. There are huge setbacks, different difficulties, and infrastructural issues. Example, you are citing. So what I am doing in AI, I am making a fake video, deep fake. That my child is, it is in my video, the child is stating, "Father, save me," that these extortionists have kidnapped me, and they are demanding 1 crore rupees or 1 lakh rupees. And the exact video that my son was stating to me. And believing on that video, I went to their areas and I paid the money. And later on I recovered that my son was actually conducting classes in his college. So the same thing has been inbuilt in your BNS. That is, extortion can be through e-world. If you read the illustration, I think 5 or 6, the illustration has been given. So we have law. I always keep saying, we have stringent law. We have included all the technologies, whatever they are till date. See, in our Information Technology Act, we have a definition of what is computer. It says any device which can process data in a speedy way. See, we have gone 100 years from this day, because we are hoping, because IBM is working for the last 40 years on supercomputing. I am not telling supercomputing for a big house. I am telling about supercomputing will run 0 Kelvin and it will be a pump-sized thing. And that supercomputer has a processing power of 2 to the power n, and n stands for 100, means you can work with the data of all the data in the world. If n is 100, then the amount of data that supercomputer can process at a time can be the data of 800 billion persons of the world. So 8 billion persons of the world. So it is the thing that we are thinking of that it can be applied. We are thinking of this can be applied, or the same thing will coming back, that it is not the evidence which is important. It is how we collect, how we preserve. If you go and watch our Malkhanas in different PAs, it's a disaster. There is no Faraday book. There is no that technology which can guard even the data from the wear and tear, humidity, rust, dust and everything. So there's a huge thing out there, and there's a very tough thing when the 105 of BNSS and 185 of the BNSS came into play. Because see, our investigating agencies do not have that forensic devices every time that they will go and catch the evidences with the hash values. And an accepted algorithm today, we are waiting 256 and the 512 we shortly be coming with. So all these are there, evidences are there. Your thing is, okay, we are working on the conduct and the other things of the process of the crime. But most important and the difficult thing, what I feel every day, is how to collect and how to present the same before the court of law.
Sir, one more question.
Thank you.
Sir, one more question. Sir, suppose we know that we have a digital evidence. Now, what is the procedure of collecting that digital evidence? Because as of I know, if we search for evidence from somewhere, which is the physical evidence, we need to follow a procedure. But what is that procedure in case of collecting a digital evidence?
See, when we are doing anything on our computer, just refresh your concept. When we are doing anything on computer, because I have worked on hardware and software, I am a lover of Python language. I myself made 11 applications. It is there in the Play Store. I'm a regular, at least 1 hour a day I code because I love to code. I'll tell you everyone to code because code is the most scientific analytical process of how algorithm runs, how you're going to make a program, how an application which can be used of people. So my point is very simple. When you're making something in your computer and after completion you are doing it in your RAM, the volatile memory, you don't, that is the farce, that's the paradox of our technology, that you cannot store on that on volatile memory. We have to have a non-volatile memory, say for example hardware or hard disks or any else media, where you have to capture and save the data, store the data. Presently the law says it's a creation and storing. The law has accepted these two terms in our present BNA. So we have to think about that we cannot do anything. The two important golden rule in cyber forensic is that we have to document every step, and whenever and whatever we are doing, we need not and should not do anything on the original device. So the thing is that whenever there is an evidence in a device and we are collecting the data within it, the best thing and the most important thing, we have to make a forensic image of the same. Because when we are doing, because I am telling you, it's not the evidence which is important. The location, bit by bit imaging of the evidence is important. So when we are making an image, forensic image or anything like this, then they will come with a hash value or a value like that which is based on a particular algorithm. So until and unless the hash or the algorithm is changed, nobody in this world can challenge your evidence telling that you have yourself destroyed the data. So the only important thing is, see, in Basit judgment, the Honorable Supreme Court says that there are 5 qualities of an evidence which also applicable to digital evidence. The most important one is the relevancy and admissibility. What I was discussing about 65B and others. Then comes the believability, the completeness, the authenticity and all these things. So today in our BNA, the 63 statement which is there in your schedule has included the hash value. And now if we can say that from the day one of collection of the data till application of the data in the courtroom, if the hash value has not been changed, then nobody can challenge your data, and that's maybe the till date one world's most important and procedure to collection of data.
Thank you, Mr. Mrs. Chatterjee.
Hello.
I'm going to the next sessions.
Hello.
No question.
One single question.
There is several
one
speakers.
single question. It is important to all of us. In future, whether AI will be functioning as amicus curiae?
It has already started in China. Why not in India? The people are telling India is a democratic country unlike China. But I am telling China was working it for the last 15 years to evolve a judge. And presently the law prevailing in China is horrific. The people are telling there will be two types of judge in a court. One is the AI judge and another is the human judge. Every judgment coming out from a mouth of a human judge will be tested through the algorithm of the AI judge. Even now the thing is that, what if there is a conflict, they are framing with the law that if there is a conflict between the AI judge and the human judge, then the AI judge verdict will prevail. You need any other answer?
Thank you. That's it.
Bye.
Thank you, sir. Now we are going to our next sessions, the BNSS, Bharatiya Nyaya Surakshita Sanhita. Now I am calling upon the stage Mr. Shurjo Kanto Baladhikari, who is actually currently working as an assistant professor with a specialization in victimology and criminal laws at the WB-NUJS. After completing his BA LLB honors from the University of Calcutta, LLM from WB-NUJS, and PhD in law from NLSU, Mangaluru. Prior to joining WB-NUJS, he served as an assistant professor of law at Sister Nivedita University, Kolkata, between 2021 to 2023, and Amity University, Kolkata, between 2018 and 2019. Guest lecturer at Surendranath Law College in the year 2018 and research assistant at WB-NUJS between 2015 to 18. Now, prestigious organizations have invited him to deliver lectures such as Central Detective Training Institute, Kolkata, Regional Institute of Correctional Administration, West Bengal, Swami Vivekananda State Police Academy, Barakpur, University of North Bengal, JIS University, Kolkata, Administrative Training Institute, West Bengal, Human Rights Lawyering Network, Kolkata. Dr. Baladhikari has also organized and participated in several workshops, training program, and faculty development programs, and published numerous articles and book chapters in journals and books of national international repute. Before joining academics, he also practiced in criminal and civil jurisdiction in the High Court at Calcutta and the District Court of West Bengal. Thank you, sir. And we would like to present you one memento. Kindly accept it. And the stage is yours.
Thank you. Very good afternoon to all. First of all, I extend my deepest regards to Sri Thakur, where this event, we can really say that law has met devotion. And without law being entangled with devotion, we cannot really think of implementation of the law. I also extend my deepest regards to the honorable judges of the High Court who are present in this August gathering. I also extend my regards to the organizers, Satsang, the legal wing, for inviting me and for having me over here. So with this brief note, we are scheduled to talk on BNSS, Bharatiya Nagarik Suraksha Sanhita, which has come in place of the Code of Criminal Procedure 1973. But before we go into the exact changes of the law, we are bringing this new law in a situation where we have concerns about pendency of cases. About concerns, so I would like to raise a few questions by saying whether this new law will be able to not generate the present pendency, which is 3.4 criminal cases which are pending in India, 3.4 crore criminal cases which are pending in India. The issues which relate to access to justice for the under trials, which comprise of 72% of the prison population in India, some states around Maharashtra and Pune, where it increases more than 90% also. We are also in a situation where the in-service training of police officer are 6.1% of the total police strength as per the India Justice Report, and they are the first contact point of the accused as well as victims, as well as the other persons known as the witnesses and other things who are associated with the process of trial. So with this few observation, let me go into the changes. So the last speakers have already highlighted that we have really brought changes in regard to the use of technology. So yes, for the first time, they have defined audio video electronic means in section 2A of the BNSS. So which rightly points out that it could be for the any communication device which is used for the purposes of seizure, transmission of evidence and so forth. So all the questions, what device which were used by the police, whether the transmission was correct or not, those questions will be now avoided in trial because any mode of transmission with help of electronic communication is accepted mode as per the Bharatiya Saksha Adhinayam or the Indian Evidence Act. They have first time defined bail and bail bond, which was very important to do because Husainara Khatun versus State of Bihar, you are all aware, 1979 they introduced the concept of personal bond. So that concept of bond has been also defined in 2D, and bail we are already aware what does bail mean. Due to paucity of time, I will have to be little quick also, so my apologies to that. They have also changed the definition of victim, which is positive in nature according to me. Previously the CRPC in 2WA defined victim, but the irony was that the definition of victim was incorporated in 2008 Criminal Law Amendment Act. So all that time from 1898 Code of CRPC, 1973 to 2008, there was no definition of victim. So we always regarded victims were byproducts of crime, if not forth. So now we have changed the definition by removing the words that the accused has been charged. So the technicality has been done away with, that the accused should not be charged or something like that which would define victim. So now it says that any injury or any loss which is suffered by the result of the act or omission of the accused person, and such person including their guardian or legal heir would be said as a victim. You all know that the first case of BNS or this law was enacted, the first case happened in the NDLS, New Delhi railway station, where the hawker were occupying that space illegally. So that's just for a piece of information. Now we are coming to the exact laws or exact changes which has been brought. I hope this comparative table is visible to you till a certain extent, I hope so. So you all know that arrest was 41 and notice of arrest was 41A, which has been clubbed into 35 now. So Arnesh Kumar versus State of Bihar had said that you have to issue notice before arresting for offences up to 7 years. But interestingly, the BNSS in 35 subclause 3 have not incorporated what Arnesh Kumar says, but has incorporated the concept of notice. So it is not in offences up to 7 years, but also offences more than 7 years can be also issued notice, which could be said as a positive thing. And also one more subclause has been added in section 35, that anyone below the person, anyone below the age, above the age of 60 years cannot be arrested without the permission of DYSP if the person has said to be accused of an offense less than 3 years or is an infirm person. So it is also a protection which has been extended. We have seen that, recollect the case of Nilavati Behera versus State of Orissa, 1993 Supreme Court, where the son of Nilavati was picked up from the house and the body was recovered from the railway track after 2 to 3 years. So we had no information which police officer came, where it took, etc., etc. So the new law in section 37 and 80 says that there has to be a designated police officer to inform or to maintain the records of the arrest digitally, where in DK Basu it was said that the information of arrest to be maintained in the police station and the police headquarters. So few of the police stations like Asansol, Durgapur and Hugli and others also have already implemented them, and we can see a column has been created in their website, arrest details. So entire details from where arrested, which district arrested is been now available in online mode also. So this also increases the scope of access to justice. Then in cases of arrest how made, which is now 43 in place of 46, now they are also saying that for women also in regard to arrest, if whichever person they wish to, the information of the arrest has to be done. Previously also it was done as a mode of practice, but BNSS is saying that more expressly now. They have also brought back the concept of handcuff in subclause 3 of 43. But handcuffs can be only used for habitual offenders, repeat offenders, and also for offenders who have done heinous crimes like offenses against women, child, and offenses against the state. So handcuff is brought back. There are numerous guidelines of Supreme Court where handcuffs cannot be implemented. So let's see how it goes ahead. Another interesting provision, which was very needed, was the proclamation. During the stage of proclamation, we see that the accused were already aware and have left India in many occasions, which also we have seen in numerous cases. Now 86 tells that the police, from the very stage of investigation, can identify such property and give the prayer to the court for the process of attachment. So that identification, especially in economic crimes, we know that the accused, by the time that process is issued, they have already left the country. So that may be a good aspect in 86 of BNSS. So in 94, or which corresponded to 91, which is also known as the 91 notice of CRPC, now is 94, which is also summons issued by the police officer. So any document which is in our mobile phone, PDF, images, all electronic documents, police can also call that. So that is what is envisaged in 94. And I think one of the speakers also said that we can be falsely implicated by the police in regard to planting of arms or something like that, but it cannot be done, sir, now, because as per section 105 and 185 of the BNSS, when the police is doing search and seizure, the entire procedure has to be audio-videographed. For example, this auditorium, if the police officer wants to search or seize, before entering, the video camera has to be switched on in audio-video mode. If this wire is being picked up, so the video should show in a continuous mode that this wire is being picked up. The seizure witnesses has to sign the video also to show that. Also from whom it is seized, they also has to sign. So it has to be a continuous video, and without any delay, it has to be sent to the magistrate. So I hope I'm informed that the state is also making rules that it would be around 48 hours like that. So now the first thing, or the first concept of zero FIR has been made statutory now. So irrespective of the place where the offense has been committed, so one can inform about the crime, but one condition is there: if the commission of the crime is been informed digitally, one has to go to the police station within 3 days, because that FIR book, I hope you all know that on the right hand side bottom, the informant has to sign over there. So without the signature of the informant, that cannot be entered into the book, so that person has to go to the concerned police station within 3 days. But also the state is making rules that while they are in the process, if it is not in jurisdiction, the concerned police station who has received the information must transfer it to the particular police station which may have the jurisdiction, which is only the objective. The objective is not to start the case anywhere, but the objective is to make police take some action upon the receipt of a cognizable information. Now, it also says that in Lalita Kumari, only 5 guidelines were raised that where preliminary inquiry to be done in matrimonial offences, in cases where there is inordinate delay, commercial offences, and so forth. But they have made preliminary inquiry statutory. For example, in 174, they are saying that 173, that 14 days of preliminary inquiry power has been given for offences between 3 to 7 years. So that means all magistrate tribal offences, there is a preliminary inquiry, statutory preliminary inquiry now between of 14 days. If they decide to start FIR, it's welcome, but the state is also should make a rule upon the concept that permission of DYSP is taken, and it should be taken in written format. It cannot be a verbal thing which can be done, and that permission and decide not to start FIR but to start go for that 14 days preliminary inquiry should be also completed within 1 day, so that within 1 day that permission should be obtained by the DYSP. But one interesting thing which has happened is that, see, we are in a situation that the common man's FIR or that common man can file the FIR in three formats. One is that FIR, which is 173 now. Second is, if the police is not taking FIR, they could have approached the magistrate under the old law 156.3, which is now 175 subclause 3. But there comes two barriers upon that. So the first barrier is the court will call for a report from the concerned police officer that why you have not started the FIR. So that could be one thing. Another thing, it would be if it is a public servant who is involved, so it would be the report from that servant why he is involved in that offense, and also a superior officer's report is to be sent that why that offense was not registered. And also we had complaints before the magistrate in section 200 CRPC, which is now 210 BNSS. There also one barrier has been installed that one show cause notice to be issued to the concerned accused person before taking cognizance of that thing. So we are seeing that in all three situations in FIR, that 14 days preliminary inquiry, in complaints to magistrate, a report from the concerned police officer to be heard, and also in complaints cases, also the one notice of show cause to the accused has to be taken, only then cases to be started. So whether it will restrict common man to approach the doors of justice, that time will going to tell. Also, one interestingly, the forensic science has been given a statutory place now for all offences which are punishable with 7 years or more, as per section 176 subclause 3 of the BNSS. The calling of the forensic science is mandatory now, and also, but no timeline of those forensic science reports has been mentioned over there. I think the honorable judges are here. They also face issues that the reports are delayed. They don't come in time, which could have helped them also to decide the cases. Also in 179, who cannot be called to the police station, they have changed that all males below the age of 15. They have also changed that all males below the age of 60 or a woman, mentally or physically disabled person cannot be, or with acute illness cannot be called to the police station for attendance as a witness, but if they desire so, they can be called. So I have been advising police that you please maintain a letter of request they wish to come, and you make also a corresponding general diary entry to that fact, so that procedural issues don't develop thereafter. Also, it was already there, but examination of witnesses by police is 180 now in place of 161, so where it could be also audio, video to be recorded. If police does this, it will also help those concepts that it is out of threat, coercion and undue influence. Now, in regard to magistrate statements, 183, so one shall clause has been inserted over there. So any person who is a witness of a crime, and in that crime it is punishable with 10 years or more, so in that situation, it will be obligatory upon the magistrate, if the police brings him, to record that confession. Also, we have been reading a lot about that police custody, increased police custody. It has a deterrence effect with the human rights. So yes, in 187 corresponding to 167, that police custody has been increased from to 40 days, where charge sheet has to be submitted in cases of 60 days, and to 60 days, where charge sheet has to be submitted within 90 days. But the catch is that in no situation the custody cannot increase beyond 15 days, which was also the last law, which has been retained in this law. And trust me that no police officer wishes to keep accused persons in their custody for a prolonged time, because now we have that judges give those directions that no mental or physical torture to be inflicted, or also within every 24 hours the medical examination has to be also completed. Yes, extended, so it could be also like that. So for example, in the initial time, the police custody was taken as 7 days. So after that, if the police is not asking for police custody, he can go back to JC, if not enlarged on bail. And then if the police is again asking for police custody, again the police custody can be extended. So that prolonged incarceration from the very first time, that may be avoided, but it also has consequences about the total detention time. Also, in 193, which is a charge sheet now, so now the charge sheet to be also submitted electronically, and the victim also has to be informed about the progress of investigation. So I raise a question over here that what do you mean by progress of investigation? Again, because the practice presently is to send a notice when the charge sheet or the final report is served. But still, what does information means? We need more clarity on that. And also further investigation was already there in 173 subclause 8. Now in 193 subclause 9, that one proviso has been inserted, that now the further investigation has to be done with the permission of the court. Previously it was also there, it was a practice, but now it has been written in the law, and further investigation cannot exceed beyond 90 days with the permission of the court. One interesting thing which has happened is about the supply of copies. Supply of copies was 207 CRPC, now 230 of BNSS, where before the commencement of trial, during the stage of commitment, the copies were to be given to the accused person to defend himself. Now, from the 14 days, within 14 days from the production or appearance of the accused, means whether he is arrested and produced or he has submitted himself and asking for bail, his right activates. So within that 14 days, that all those documents has to be given to the accused. But the police are raising question that from the first day we are sharing all the documents, then there would be nothing confidential about the investigation. So I always tell them, now it is a law. So we have been going to numerous jails on part of our NUJ's project on access to justice for the inmates. So there we are seeing that there are some people more than 80 years who are in jail and for longer period of time, and sometimes those can be avoided by having the copies right away. So this could be also said that we have an improved chance of legal representation. So in regard to the courts, the only change is that the Court of Assistant Session Judge has been removed. In regard to the special commissioners, we already know the Calcutta Police CP is having the powers of the executive magistrate. Also the district SPs has been given with the magisterial powers under section 15. And also in regard to, I come to the courts now. So in Directorate of Prosecution, 3 new subclauses has been added, 20 subclause 7, 8, 9 and 10. So where they are proposing to set up District Directorate of Prosecution. So District Directorate of Prosecution will have a Deputy Director and Assistant Director. So their role would be to monitor cases which are punishable with 10 years, below 7 years and 7 to 10 years. And which would also, they could scrutinize police reports and give opinion on filing of appeals. But the sad part of the law is section 20 starts with that line that the state may. So the word may is over there. So how far it is going to be implemented, we are not sure. But if it is implemented, it would be a very beneficial thing for the police also to have some legal opinion before filing of the charge sheet. Because in every case, charge sheet may not be filed, or in every case, there may not be the cognizance given. So these are scheduled to change the law. And also in regard to power of court, everything remains same, but in regard to first JM, the fine amount has been increased from 10,000 to 50,000 now. And another form of punishment in section 2H, I think Faisal was speaking, as the community service has been introduced as a form of punishment, like theft on first occasion, or deterring the public servant to do any offense, and some other offenses that, but the definition is that anything for the benefit of the community. So I interpret is that we are having juvenile homes. We have seen there the condition is not very good. So in those regards, the courts, the judges may ask the accused to do some infrastructural changes, developments over there. Plantation of trees are always recommended. So these things may also help the court in while giving the punishment. Sir was also already speaking about that electronic things. So now in electronic mode also, the summons can be delivered. So one of the hiccups in the present justice system is serving of summons. After that we have warrants, proclamation. So that summons can be also sent now electronically. One interesting change is that a summons can be now delivered to any adult person. That male adult person has gone away with, and also the police and the court to maintain a register where the email ID, where the phone number and etc. to be maintained, which will be the correct person to communicate or to serve the summons. Only a proof of that service to the satisfaction of the court is asked in the law. So prosecution, sanction, there is a major change. I hope already we have read in newspapers, and the matters are pending also for asking of sanction. So now they have said what? Maximum 120 days time to the government will be given to obtain sanction. If no response is received, it is to be understood as deemed sanction. So whether this would go against the principle of natural justice or not, that is time is to tell, and I hope the courts will also tell us that what will be the correct thing to do. So this deemed sanction has been also introduced. Also in regard to commitment, so in mostly the most changes in the 3 new laws has been brought in regard to BNSS. And first time we see a timeline has been installed in all the respects. So in regard to commitment of case, I have seen in the courts, sometimes with due respect to the honorable judges over here, that it's taken years to commit one record to the other. So now we have a specific timeline that between 90 days and 180 days this commitment procedure has to be completed. Also I have already discussed the supply of copy within 14 days from appearance or production of the accused to be given. And the victim, if represented, can also get the copies within the meaning of 207, which is now 230 of BNSS. In discharge of accused person also we have a timeline. So it clearly says 60 days from the stage of committal of the case that discharge application to be preferred, because we have seen the matters in the court, the accused any point of time they feel like preferring the discharge application and dismantling almost the process of the court. Also for the first time we have seen that framing of charge also has to be completed in a timeline. So 60 days from the first hearing of charge, that charge framing also to be done. And it is saying very interestingly that the presence of the accused can also be in electronic means, so that the accused is not coming, we are not able to get him, because there was a judgment of our High Court only, Justice Bagchi's judgment, where it's correctly said that we are not touching the accused person. So the analogy was that while we are watching a cricket match in the television, we are seeing the same score while we are sitting in the field and we are sitting in the home. So same analogy can be rightly thought over here. So it can be done electronic means also, and 60 days from the first hearing of charge. Then prosecution evidence is to be also taken. So all the witnesses, deposition of police officer, public servant can be done by audio video in session trial. In magistrate trial they have not said so, but we have a provision in BNSS later on, that 530, that all proceedings of the court can be held in electronic mode. So we can say that cure can be done in the magistrate trial also. And for the first time we are seeing that the judgment delivery to be also done in a particular time frame. So it is to be delivered within 30 days and not to exceed 60 days in sessions cases, and for magistrate it is up to 45 days from the conclusion of the trial. Then we have also seen that the courts are also aware, or we have seen that lot of time petitions are filed. We are aware about 309 CRPC applications. So now in that 346(2)(b), so there has been a change which has been introduced. So not more than 2 adjournments can be granted after hearing the other party, and the circumstance should be also beyond the control of the accused. So we have to also see in the future how that is implemented. Another new thing has been introduced as in absentia trial. We have a lot of countries which already have this concept of in absentia trial, but the funny analogy, let me tell you, you can try the person, not punished if you are not able to still apprehend him. So, but ideally it would help. So let me just clarify the procedure. So within 90 days, so 90 days has to be lapsed from the framing of charge. 2 warrant of arrest in consecutive of 30 days, means another 60 days has to go away. Then there has to be newspaper publication within 30 days that the trial has commenced, where he used to stay, that all that information about the trial has to go, and entire videography of the trial has to be also done. And after that, 3 years have passed, the accused cannot come and also file an appeal. And if he wants to argue or defend himself, he has to come in during the pendency of the trial, only then that the chance of defending can be granted. So it is a new concept, 356 of the BNSS, which speaks about in absentia trial. And then we have, yes, so in cases which are other than warrant or summary trial, so a few new offences has been introduced, like theft, dwelling house, and dwelling house, which was 380, was only dwelling house, which is now 305 BNS, which has increased the scope that it is not only dwelling house now theft of idol from the place of worship, while transportation, if anything is theft, or any theft has been done by the clerk. So all, if up to the value of 20,000, the trials can be summary trial. Also the change in summons case is that 30 days notice to the complainant will be given now. If the complainant himself or herself is not coming, then the court can discharge the accused person right away under section 274 of your BNSS. Now few changes has been also brought in the general principles of trial, that withdrawal from prosecution, now which was 360, 321, only changes one proviso has been inserted in section 321 BNSS, that the victim has to be informed before withdrawal. But sir, with the presence of 338 subclause 2, corresponding to 301 subclause 2, that the victim's advocate would only assist the prosecution and can submit written notes of argument after the stage of evidence is closed. What good does the notice do to the victim in cases of withdrawal from prosecution? So that's one concern. We all know that in cases of people of unsound mind, trial cannot be done. So the use of unsound mind has been implemented, and idiotic and all those terms has been gone with the help of the Mental Health Care Act. So in treatment of victims, they have included POCSO victims in section 397, that the state has to give treatment. But my question is that why only POCSO and rape? So 357C, only the offences of rape could qualify for treatment, but also POCSO. But why only these two categories remains another question. Sir was already speaking that we have now the witness protection scheme. But the problematic situation in 398 is that in Mahendra Chawla's decision, the Supreme Court already have framed the draft witness protection scheme. Our High Court also have a scheme for the vulnerable protection. But in the new law, they could have created a draft scheme which could the state implemented, because right now the situation is that state will implement, which state, when implement, and then will be notified and applied. So that also is a concern right now. In regard to mercy petitions, we had seen in earlier or in news that each accused is preferring that mercy petition one after other. So now that situation has been cured. So within 30 days of the committal of the information of the death sentence, that has to be informed to the governor. Now from that 60 days, the president, if even one person accused files, all the files will be sent to the president. So 60 days to that. So jail super has to do that. Another within 60 days, the president has to decide along with the state government. And no appeal can be preferred from the decision. So the changes has been brought. Now comes the situation of the under trials, 436A, which was incorporated by the Act, and now which is 479. Supreme Court very recently have said that it would have retrospective application for the benefit of the under trials also. So that the change is that first time offender, 1/3, if they have completed the sentence, they are eligible to file the application. In other cases, it is half. Multiple cases, if one has, it cannot be allowed. and jail super has to inform the concerned DLSA through the DLSA that those persons who are completing 1/3 and 1/2 of the punishment as they are eligible to file the bail application under section 479 right now. In regard to anticipatory bail, so one clause has been added that rape below 16 years and gang rape that cannot qualify for anticipatory bail. So that is the only change which has been ordered. There has been also made change in the disposal of property. I hope we are all aware about Sundarlal Ambala versus State of Gujarat, 2002 Supreme Court, where the court, because of the court decisions, we have 52A of the NDPS Act. But we did not have a similar provision in Bengal excise law because it is one of the oldest law in the country. So in 497 BNSS, it is saying that within 14 days, the description of the property has to reach the court, and that entire, while the destruction or the destroy has to be done, that video recording of the audio video recording of the same has to be done, then the court can order for disposal, destruction, confiscation of the property as the case may be. So it is a welcome change again. In regard to, yes, I was saying that in 530, which is a new section, it's saying that trial and proceeding to be held in electronic mode. So as I had said that in sessions it is possible, so in magistrate also 530 can cure that, all the evidence can be also placed through the electronic mode, because we have seen, especially in case of government officials who are transferred here and there, they are not able to come and seek more time. In plea bargaining also, the role of victim was already there, but now the timeline has been incorporated. What is that? So within a period of 30 days from the date of framing of charge, so the accused has to decide, I am availing this or not. And then 60 days time will be given by the court to decide a mutual application with the public prosecutor, complainant, and also the victim can be incorporated. Then 1/4 of the punishment if first time offender, and 1/6 as the case can be also given. But interestingly, in 531, which is the repeal clause, all cases which were pending. So I really accept at this juncture that the courts, the prosecutors, and the defense are in a lot of pressure right now, because old cases which were pending, all inquiries, trial, which were pending investigation to be as if the CRPC was in force. So, and the new cases which are from 1st July to be covered as per the new law. So right now, two procedures. I hope that no trial has begun with the new law. So I hope that very soon. So by when we can completely say that it is not the gestation period, we cannot be very, very sure of right now. Rights of victims, I have already told while I was speaking, but I just like to point out Jagjit Singh versus Ashish Mishra alias Monu, April 2022 Supreme Court, where especially in paragraph 20 to 24, Supreme Court have rightly said that the victim has an undeterred right of participation in the criminal trial, and that cannot be disturbed at all. That is the words of the Supreme Court. It is not my words, but still we have written 338 subclause 2 that the victim's advocate can only present assist the prosecution. Assistance is what? If I require assistance, I will ask, else you sit down over there. And also after the written notes of argument can be filed after the stage of evidence is closed. What is the point in submitting any written notes of argument? So that 18 subclause 8 where the victim advocate can be engaged. So I have always said that the victim justice is one step ahead and two steps back. And a copy of the FIR can be given to the victim, because the word informant was there. Now they have inserted the word victim also. But why not the charge sheet also? I also raised this question in this forum. And also only victim of rape, that the statement to be recorded in her place of residence. I am not saying why rape. I am saying why only rape. Other victims of crime should be also extended with this kind of protection. Medical examination from the doctor should reach within 7 days to the concerned IO, which is a welcome step. We have heard from the police recently that it takes time at times. Then supply of copies to be also given to the victims if they are represented. Why? even if they are not represented, the court has the address and the information of the police. We can give them. They wish to avail it or not, it is their wish. So that's what rights mean. Then again, if there is, I have already said that about the application of any application is there in the magistrate court, but it is traveled by the session court. Any application pending to be also sent to the committed court. And lastly, I have also spoken about the hearing of the victim in the withdrawal proceedings. If the victim has no participatory rights, what is the point in extending that only the victim to be served with a notice? Then court not to be open. Court not to be open, which was 327 in one of the states recently, 2-3 years back, we saw that the victim was present, and it was the third day in the presence of the accomplice. The victim was giving the statement, and the victim said that my statement would be read by the NGO persons who had come to give care to her. The court said no to that fact. Victim fell unconscious. Court thought it is contempt and started a contempt of proceedings act. So why court not to be only open for offences of rape and POCSO? What about other offences which are against women and child? That is another place to look forward. Then comes victim compensation scheme. I had myself gone to almost 20 districts of West Bengal and 18 states data I have collected from India, which says that we do not have dearth of money now. We have money, but there is lack of coordination between the police and the DLSA, and also the provisions are so. Because provisions saying what? That court may recommend compensation to the DLSA, which means what? That the DLSA would quantify the amount. So I am saying that if the court can conduct trial, punish up to death, why not the court can also quantify? Because again the DLSA has to do the inquiry for 60 days, which may also extend for more time, and the victim is waiting endlessly in the present trial. Also, one clause is there, 357A, now 396, that if the accused is not apprehended or the trial not started or not identified, but victim identified, then only we can pay compensation. Now question comes, if accused is apprehended, identified, trial started, then we do what? Shall we wait for the entire trial to be completed and then the court again, the words are there, court may award compensation. But many Supreme Court guidelines are there. Ankush Shivaji Gaikwad, Suresh versus State of Maharashtra, courts have said it is a general principle to award compensation. And lastly, coming to treatment of victims, only POCSO, acid attack and rape qualifies for treatment of victims. And to conclude, I would like to think about what Shri Thakur have said. Let the search for the truth be continued. Thank you. Namaskar.
Thank you so much, sir, for your enlightening discourse. Thank you once again.
Is there any question? We take it.
In our interaction, it is the time to interact. If anybody having any question, you can, yeah. Please, Mike.
Hello. Hello, sir. Thank you for your wonderful presentation. I would like to ask one thing. As per section 355 and 356, which is trial in absentia, the entire thing is said to have violated the natural principle of audio alterum partem right to fair trial, and it is also against the ICCPR guidelines which India is a party to. In the era that we are saying that these laws are revolutionary as they decolonize the entire structure that the British made, isn't having someone tried, not even being present in the court, the very thing that the British would abuse to have an Indian revolutionary punish for something he might or might not have done? Thank you.
I am not denying in what you are saying, but I would just like to add that before we call someone for trial, there are certain procedures we follow. We issue process And by issuing process, we send summons. If summons is not working, we issue warrants. We issue bailable warrants. Not working, we issue non-bailable warrants. Still they are not coming. We issue proclamation. Still they are not coming. And in all these stages, there are timelines of 30 days, 60 days, which the court gives. We also issue forfeiture notice. That also we give notice that you come and explain why your property not to be forfeited. If comes, the law also says that property will not be forfeited. Then comes the situation of absentia trial, in absentia trial. And there also 90 days time from has to lapse from the framing of charge. 2W warrant of arrest has to be executed. Local newspapers, it has to be circulated. Accused where last resided, the entire locality will be informed. Court will publish notices. Then entire videography of the trial is done. The law also said that if you come anytime between trial, you have the right to cross-examine and bring your evidence. If not, then I am saying that no, nothing doing. Yeah, constitutional courts will have their own things to say, so we are all waiting for that. So it is absolutely not that we are not informing him anything and we are trying. So it is also not that. Thank you.
Thank you, sir.
It says that, in particular section of search and seizure, it says that there has to be 2 local witnesses that has to be present when the search and seizure is taking place. And certainly if those 2 persons deny or they refuse, then action will be taken against them. So, of right to choose not to be a witness, and those 2 persons have to be a local inhabitant. Do you think that there arises any kind of right to choose?
See, and this will all be solved by the provisions of 105 and 185 that the entire search and seizure has to be audio videographed now. Because police always claims that we did not find a local witness and the witnesses also say that I do not wish to be a witness in the case. So that audio video recording of the search and seizure under 105, under regular search and also during the investigation of the search has to be audio videographed now. So please read 105 and 185 of BNSS. That would solve.
I think that's all.
Yeah, thank you.
Thank you so much, sir.
Thank you.
Thank you so much.
Be quiet, balanced, and meditate the law. Seek out the way and opportunity to apply it for the generation of vigor and vitality. Consider rationally, with tactful observation, how and where it is to be applied, by which relief of life may come automatically. Be thou happy and make everyone happy.
Thank you. It's my immense pleasure now to invite on the dais Honorable Justice Apurva Sinha Rai, the Kolkata High Court, deliver his speech on the Bharatiya Saksha Adhiniyam 2023. We'll be honoring him with a memento from the VIDHI-VIDATH side.
May I start? Take few seconds just to adjust the screen with the laptop. Today His Lordship is speaking on
ভারতীয় সাক্ষ্য অধিনিয়ম 2023.
So, Lordship may start.
Good afternoon to everybody. After offering my respectful obeisance to the lotus feet of Sri Sri Thakur Anukulo Chandra, I would like to convey my thanks to the organizer for giving me this unique opportunity to share my views with this august gathering. I know that this All India Legal Seminar is the brainchild of Sri Sri Acharya Dev of Satsang. I also offer my respectful pranam to the feet of Sri Sri Acharya Dev. I also like to congratulate our Honorable former Acting Chief Justice of High Court Calcutta, Sri Pratap Kumar Rai, Dr. Faisal Fasi, Dr. Surjakanta Baladhikari, Mr. Bivas Chattopadhyay, Mr. Taposh Kumar Sahu, and Mr. Papai Chanda. I also convey my thanks to the learned judges, learned advocates, teachers, professors, my beloved students from various universities, colleges, the disciples of Sri Sri Thakur Anukulo Chandra, other dignitaries, ladies and gentlemen. Before I start, I want to convey my feelings. The organizers have disclosed my identity, one of my identities, as Judge of High Court at Calcutta. Yes, this is true, that this is my official designation, that I am a Judge of High Court at Calcutta. But I have another identity of mine. I am a disciple of Sri Sri Thakur Anukulo Chandra and Shahopati Ritik of Satsang Devghar. And that is the most important identity of mine. I got the holy name in 1968, and I have a long association with this great institution. I am proud to be a Satsangi and proud to be associated with this institution. I do not find any conflict between religion and science in the ideology of Sri Sri Thakur Anukulo Chandra. Each and every religious tenet of Sri Sri Thakur Anukulo Chandra is based on certain scientific experimentation, principles of science, be it physical science or social science. If you want to be a lawyer, His Holiness indicates how you can become a great lawyer. If you want to be a judge, His Holiness says how you can become a great judge. Likewise, if anybody wants to be an ideal doctor, ideal professor, ideal politicians, ideal engineer, every aspect he considers. His Holiness indicates how a person can excel in his profession ideally. I have no hesitation to admit, had the ideology of Sri Thakur Anukulo Chandra not been in my life, I would not have become a judge of High Court of Calcutta. This is my feelings. I think the incidents of Sandeshkali are quite fresh in your mind. Is it correct? Incidents of Sandeshkali are still fresh in our mind. To recapitulate, I indicate what happened there. There was serious allegation that land of innocent people was being grabbed illegally by some antisocial. Several women were sexually exploited at the gunpoint. Several mischiefs were committed in respect of certain immovable properties. Problem is that the law enforcing agencies were not taking any steps. No FIR, no complaint was received by them. There was a huge uproar throughout the country. Journalists were not allowed to visit there. Outsiders were not allowed to visit there. Nobody was taking any steps. At that critical point of time, I, being a justice of High Court at Calcutta, took suo motu cognizance of the said incidents and referred the matter to the Honorable Chief Justice's Court. And you know, thereafter, the bench of Chief Justice issued certain appropriate directions, and the matter ultimately yielded some results. I am not here to beat my own drums, but I always ask, who encouraged me, who inspired me to take this bold decision? I know my belief in the ideology of Sri Thakur Anukulo Chandra, my belief, my faith in the ideology of Sri Thakur Anukulo Chandra encouraged me, inspired me to take such bold decisions. Sri Thakur Anukulo Chandra, in his book VIDHI-VIDATH, has categorically stated that every allegation, whatever it may be, should be investigated by an impartial and independent mind. With an impartial and independent mind, the investigating agency should consider every aspect of the allegation so that they can reach to the conclusion, to the root cause of the allegation. You know, being law professional, that collection of evidence, collection of materials are very much important. The purpose of law of evidence is to set out the parameters that which evidence or which material should be admissible in court. That is the ultimate thing. Which evidence or which material collected by the IO is to be admissible in court. And another object of any enactment is to consider the present need of the society. Present need of the society is to be considered by the legislature, and accordingly the legislature enacts law considering the present need of the society. You know that Bharatiya Saksha Adhiniyama has been brought into effect. Now, what are the reasons for bringing these changes? I have listed at least 5. According to me, there are 5 reasons. Unfortunately, I have prepared this presentation and contacted with them, but they are unable to show the same in your projector, whatever it may be, please excuse us. I have recorded 5 reasons. Rapid development in e-commerce activities throughout the world. Second, tremendous rise in the use of laptop, mobile, and other communication devices in our day-to-day life. A large number of offenses is being committed by using digital platforms. The data stored in laptop, mobile, or other communication devices are sources of information which can be used as evidence in civil and criminal cases. Data in which such devices can also be used by the law enforcing agencies as lead to investigate criminal cases. Need for including data found in communication devices to be recognized as pieces of evidence. These are, according to me, 5 reasons. The list is not exhaustive. Now, there are 2 important changes in the definition portion. What is that? The document, the term document and the term evidence. The document is now include not only the traditional document, but also electronic and digital records. If you go through one illustration in the definition document that has been added, that has been inserted, that is illustration number 6, it will clear all our confusion regarding the present day document. Apart from traditional document, the digital records, it is said like that: an electronic record on emails, server logs, documents on computers, laptop or smartphone, messages, websites, locational evidence, and voicemail messages stored on digital devices are documents. Now, what are the digital documents right now? Our laptop, smartphone, DVD, CD, everything is now our communication devices are now containing evidence, and it should be regarded as documentary evidence right now. Now, there is a change in evidence, the term evidence. We know evidence means oral evidence and documentary evidence. Now, oral evidence means the statement or deposition of the witnesses. The change is that now deposition or statement of witnesses can be recorded through electronically. And another change is that in documentary evidence, it has been stated that all documents, including electronic or digital records produced for the inspection of the court, and such documents are called documentary evidence. Now, I have considered the entire provisions of this new Adhiniyam, and I find that Section 61 has clearly stated or has clearly put the electronic and digital record at par with documents. There were earlier some problems, and now the problems have been solved by putting Section 61. It has been stated therein, an electronic or digital record shall, subject to Section 63, have the same legal effect, validity, and enforceability as other document. The admissibility of such record in evidence cannot be denied if it is produced as per Section 63 subsection 4 of Adhiniyam 2023. Now, on earlier law, that is Act 1872, there was a requirement of production of certificate in proving electronic record. Now, the question whether the said requirement is still subsisting under the new law. Section 63(4) of Adhiniyam 2023 reiterates the requirements for submitting certificates. And the most important thing is that format of the certificate has been annexed in the schedule to the Act. Earlier, a certificate signed by a person in charge of the computer or management of relevant activities was sufficient. But as per new Odhiniyam, in addition to a certificate signed by the person in charge of computer or communication device, another certificate duly signed by an expert must be submitted. So there shall be a combined certificate. Combined certificate, it contains two parts, Part A and Part B. Part A shall be filled up and signed by the person who is in charge of the mobile, smartphone or communication device. He has to fill up that I am the owner, I am the operator. If it is my mobile smartphone, then I have to fill up the first part, Part A. And Part B is to be filled up by an expert. Part A, I am unable to show. Thank you. Part A and Part B. Next slide number 7. So Part B is to be filled up by an expert. Now, who is an expert? Section 63. Section 63 is earlier Section 65B of Indian Evidence Act. Section 65B of Indian Evidence Act is now Section 63. Section 63 does not define who is an expert. Now we can take assistance from Section 79A of Information Technology Act, which indicates examiner of electronic evidence as an expert. So anybody who has experience in the digital world or digital records, he may be regarded as an expert. However, Section 39 of Odhiniyam 2023 may be looked into for understanding what is meant by the term expert. Slide number 10. Now you know, previously it was Section 45 of Indian Evidence Act, and now it is Section 39, that is opinions of experts. Now change, if you can see the change, when the court has to form an opinion upon a point of foreign law or of science or art or any other field, these words have been inserted, or any other field. So anybody who devoted his time study in electronics record or digital record, he can be regarded as an expert. Now, Mr. Bivas Chattopadhyay was kind enough to mention that electronic evidence and digital records are now become primary evidence. Yes. What is primary evidence? Earlier it has been said, which has been also written in this act, primary evidence means the document itself produced for the inspection of the court. Where a document is executed, there are two explanations in the previous sections. Now, slide 12. Now, these explanations were retained or have been spread over in section 57 explanation 1, 2 and 3. And section 62 is now section 57 of primary evidence. But nicety is that 4 explanations have also been added. That is the slide number 13, please show. This is the vital for our purpose. Explanation 4, digital electronic record created or stored simultaneously or sequentially in multiple files. Each file is primary evidence. Please forgive me for a second. Digital electronic record created or stored simultaneously or sequentially in multiple files, each file is primary evidence. Now, I am not a technical person, but I have understood that in banking organization, my account is being updated by some data entry in the bank. He is entering some data in computer in front of his, but this system is that whenever he enters some data in other files also, it is being recorded. So this is one kind of illustration. Explanation 5, electronic record produced from proper custody, if not disputed. That is after compliance of 63.4, that is a certificate with, along with the certificate of expert. If produced, it is primary evidence, subject to condition that it is not disputed by the concerned person. Explanation 6, video recording simultaneously stored, broadcasted and transmitted to another device. Each of its stored recording is primary evidence. A cricket match is going on in Eden. It is being simultaneously stored, broadcasted and transmitted to other devices. Now I'm watching this game in my mobile. Just at that point of time, if I record that clip or something like that, it is now primary evidence. Now, if we record anything in a marriage ceremony or anything, we are recording video. These are all primary evidence subject to compliance of section 63.4. Electronic record automatically stored in multiple storage space in a computer resource. Each automated store is primary evidence. Now, time is very short. We have to conclude within 2, I think, and another speaker is there. The ambit of secondary evidence has also been expanded by section 58 of Odhiniyam 2023. It includes oral evidence and written oral admissions and written admissions, and evidence provided by a person who is skilled in examining certain documents, which being technical or voluminous, cannot be conveniently examined in court. The question of secondary evidence comes when primary evidence is not available, or at that time, after taking permission of the court, secondary evidence can be produced before the court. Now this is now oral evidence, oral admission and written admissions. Now one salutary principle has been added that has been mentioned by Dr. Baladikari, that is proclaimed offender can be tried in absentia under section 356 of Bharatiya Nagarik Suraksha Sanhita. Has been added in section 24, that is the old section 30 of the Indian Evidence Act, that if any confession is made by an accused who is being tried jointly with other accused and one of them absconded, then such confession of the accused can be made available in respect of other accused, even the said accused who absconded, who is a proclaimed offender. That is a section 24. Now certain words, that is slide number 15. Some archaic words are there. Her Majesty, or by the Privy Council, Parliament of United Kingdom, Provincial Act, notification by the... These are all archaic words and they have not been inserted as they are no longer relevant. Now, for the purpose of clearing confusion of some of the audience, I am referring slide 16, that is a repeal and savings clause, which says in essence that any pending trial, inquiry or investigation just prior to 1/7/2024, they shall be governed by Indian Evidence Act and not by Bharatiya Sakya Odhiniyam 2023. And this is all for this audience now. You can put me questions, I can give you answer, because we have to complete within 15 or 20 minutes. If you have any question. So thank you very much. I also congratulate all of you for giving me a patient hearing, and I also offer my respectful pranam to our Administrator General, Sri Anindo Duti Chakraborty, for arranging all this.
Sir.
Yes, I am here, no problem. Yes.
I have a question.
So you are from Salkia?
Yes.
Oh, I know you. That is the only problem. Okay.
Good afternoon to you, sir, and good afternoon to everybody. So my question is that how do the rules of evidence under the Bharatiya Saksha Adhiniyam intersect with the principles of natural justice and fair trial?
So everybody should be heard. First, fair trial. India is the best country which can boast about it. You know what is a Kasav. How many persons were killed by Kasav? How many? No lawyer was not standing in favor of him. But the law of India has said, even if he was not represented by anybody, the state will engage a counsel at his own cost. So that provision is also contained in Bharatiya Saksha Adhiniyam or other criminal laws. So I think that has been taken care of. Thank you.
Thank you. Thank you so much, sir, for your valuable speech. And rather, I must say, it was really inspirational. And we think that we are really inspired by your speech. Thank you once again. Jai Guru. Now, last but not the least, we have a speaker. May I invite on the dais Advocate Papai Chondo from the state of Dimapur, Nagaland, practicing in Guwahati High Court, Kohima Bench, as well as in the District and Session Judge Court, specialized in civil and matrimonial matters, will deliver his speech. The topic will be definitely on family matter, family laws. Thank you.
His Excellency Justice Apurva Singh Roy, respected all. I won't take much time, but I will take the opportunity to thank this legal wing of Satsang to have arranged this, and it's an outburst of knowledge and wisdom for all of us. Of course, I also give my regard to all your energy to have continuously sat here for almost nearing 5 hours, and hats off. Dear friends, I was been told to say something about family law, which predominantly deals with marriage, divorce, succession, inheritance, you can say, maintenance. Now, if we can segregate this, family laws, if we can take it in, if we say that it's one part as personal law and the other part as secular law. Personal law are those laws which is codified by one's religion. Suppose someone is Christian by religion and he wants to avail divorce, get divorce from his wife or husband. Now, he has that Act, Divorce Act 1869. One who is a Hindu, he can opt for Hindu Marriage Act 1954, 55 in fact. So, these are the acts which guides this person's laws. Suppose someone is claiming maintenance, and that is a secular law enacted by the lawmakers. So 125 CRPC, and the new law perhaps it's 144 BNSS, that may be confirmed. So what I actually mean to say here, and I just complete in 5 minutes, believe you me, that we all today are here from a family. We came here from a family and we'll go back to that family. So what matters the most is that the principles that is developed in the family, and that principle circulates in the society. For instance, if you can recall the Football World Cup match, you can recall the team of Japan. The day they played, after the match was over, the audience, the Japanese, they cleared the entire stadium, and that was taught, actually no one, no commentator or no one, there is no dictum. In fact, I feel that some audiences act like hooligans, but you see the Japanese audiences, they cleared the entire stadium, means they were taught in their family, and that has to be developed. So someone breaches a law, if you go deep into that, we will see, we'll understand that in the family tree, there is something wrong. Something wrong has been preached to him. And therefore, as an individual, we need to rectify ourselves. And there the law establishes. Dear friends, everyone requires an individual identity. And that identity can be through the path of truth. And that can be cultivated in that family. And therefore, this matters the most for us. The way we teach, the way we preach our generation next in our family, that will guide him in his future prospect. I have handled more than 200 divorce cases in my 17, 18 years of career. And if someone be with me for an hour, he'll like matrimonial matters, like taking initiative in matrimonial matters. But what I experience in those cases is that the wrong selection. We have never thought of our, from which caste, community, creed someone belongs. Bangsho, Borno, Gotre, kono hisheb nei. And we commit to someone without thinking of anything else. And these are the main causes. And I maintain files and I have the evidence of everything. And therefore, we need to think of how we can commit to the society, how we can change ourselves. I'm here not to lecture anyone, but I'm here to learn. And when I say, I'm saying it to myself also, that how to make our commitments to the society Suppose an engineering student, he wants to commit suicide. He has developed a tendency to commit suicide. Now, counseling that student is a must for us. And that is law. He changes his mind. And that is the established law. I have a law book in my hand, family law book. But I don't have any peace and tranquility in my family. Whether this will suffice the cause? Never. We have established laws, but if it's not implemented practically, there will be no help as such. So, everyone has to have an ideal centric life, which can guide us, who can show us the way how to continue with our life, with our motto. And I'm not telling it from any books. I'm just sharing my experience, what I have witnessed, what I've got in my life after getting initiated with Sri Thakur. And therefore, I pray to the lotus feet of Sri Thakur for all your well-being and better future. Thank you.
Thank you so much, Papaida, for your resourceful speech.
Thank you.
We are honored. Thank you once again. Thank you so much.
We have Honorable Mr. Justice Pratap Kumar Rai, the former Acting Chief Justice of High Court, Calcutta, who has kindly agreed to give a short speech in this occasion, and we would be happy to get him on dais.
Time short. Time খুব short. Time short. এইটা লাগবে, বইটা লাগবে না। বইটা তোমার কাছে থাক, ওখানে দাঁড়াও। হ্যাঁ, বেশিক্ষণ লাগবে না আমাদের। হ্যাঁ।
Now presenting a memento on behalf of the VIDHI-VIDATH to Honorable Mr. Justice Pratap Kumar Rai.
Welcome, my friends. All are disciples, many disciples of Sri Thakur, Anukul Chandra are here, students are here. My pranam to Sri Thakur and the Sri Bodda, Sri Dada and Acharya Dev. Present Acharya Dev. This is a pleasure for me to be here because actually when I was requested to be here, I agreed because now I am not frequently going outside because but being present here, I am really got much pleasure. After a long time with the association, with my friends, so many persons are here. So, my first contact with Sri Thakur was through my father. He was the disciple of Sri Thakur and Gulchandra. That was 1965. I was preparing for my higher secondary examination, 11 class examinations, scheduled in 1966 in there. I got initiated. And thereafter, physically I was in touch with Thakur. That was through my mother. My mother took me to Devghar. I was their student of BSc second year at that time. Then my mother, with anxiety and worries, naturally for her son, placed a prayer to Thakur about me, what will happen, what would be. Then Thakur at that time was ill, little bit, because that was the year 1968. And then Thakur, with a loving voice, answered that yes, everything will be good. I touched the feet, I got the opportunity to touch the feet of Thakur. Thakur was lying on the bed and blessed me. I think that's the reason I am here today. Thakur has made me, prepared me, given the courage to fight. Because I was involved in the politics, which was very, at the time was a very dangerous something. My life also was at stake. But I relieved from everything. So what I understood from the long association with satsang, that the values formation is the best thing in the life. If you do not have any values of your life, if you have no moral courage to fight, you will not be able to resist the evils. And if you want to give the society a service, you have to fight for them, for the poorest to the poor community. And the present, now today's discussion is on issue of the present new laws of 2023 by changing the earlier IPC, CRPC, Evidence Act. All sections have been preserved, some have been deleted, some is not in use, some having been added for the purpose of proper investigation, punishment, etc., in view of the social need. But law is actually evolves from the society. It's the dynamics of the social reflections. The society will proceed, law also will change, law will vary. Earlier, which was prevalent as a law, good for the society, it may not be good for the society, or new things to be considered. And for that, there is a supreme lex. That is our Constitution of India. That Constitution of India is the mother law for codifying any statutory law. Other statutory laws cannot override our constitutional mandate. We have in our Constitution a golden triangle, Article 14, Article 19 and Article 21. These are all regulating every codified laws. Equality, the different rights, and 21 is the very accurate provision in the Constitution which provides that nobody to be deprived of his life without the fair procedures of the law. That is a protection. Earlier, in Gopalan's case, the court held, Supreme Court held, that here the law means the codified law. We will not interpret further. But it got a jerk in the Maneka Gandhi's case. Supreme Court dealt with the issue and held that no, it should be the fair and just procedures. These fair and just procedures going deep in the area of codifying in the law, codifying any statutory law. And considering that the present codified law as has been discussed today, has taken note of everything. The community service as presently considered by the present Act, this community service was not in vogue in India, but in other countries it is there. But there is no quantification of this service vis-a-vis the punishment. As for example, you see in the Finland, one-day community service equivalent to 1 hour service equivalent to 1 day imprisonment. In France, it is 8 hours for 1 day. In Australia, there is a variation from minimum 40 to maximum 700 days, 700 hours. So all the variations they are, but in our present Act, there is no provision to that effect, how it will be calculated, how it to be implemented. Now possibly there will be notification and others or some amendments, but this social service concept for the some petty offences, that is really will serve the purpose, because law is not a deterrent. Law is not for the to punish somebody, because all human beings are the gift of the God. All human beings have all the potentiality. Sarvang Khalidang Brahmang, as Upanishad says. In every human beings, that is the Brahma. Brahma is omnipotent, omnipowerful, and omnipresence. And all the human beings are Amritasya Putra. The shloka in the Upanishad invited the entire world that we are the son. Amritasya Putra, we are the son of Amrita. Amrita means this Brahma, omnipotentiality. So, if we nurture the human beings properly, that particular persons will be beneficial for our society. And we will help the society to cure all evils. So if we just hate the sinner, then that man will be lost. Sinner will be lost. But if we love that gentleman with a smiling face, we will be able to change his characteristics. This change and modification and correction, that is the total view. And all human rights concepts also echoing in that point of view. We have in our hand the Universal Declaration of Human Rights 1948, the International Convention on Civil and Political Rights, and International Covenant on Economic, Social and Cultural Rights 1966. We have the Convention Against Torture, 1984, the United Nations Declaration on Basic Principles of Justice for Victims of Crime and Abuse of Power, 1985, and the Convention on the Rights of Child, 1989, and further other conventions. So those conventions are looking at the face, and court is bound to consider those conventions, charters, international charters, to implement and to pass the appropriate judgment to that effect. And in our constitution also that provision is already there. under Article 51C, the court must take into account these international charters. And those have been taken note of in the present 3 acts as already enacted and codified. So my friends, so taking note of all those things, and our time is also very short, we have to finish very well. This community service issue only, the last word of Sri Thakur also. Thakur also introduced, from his, at the time there was no such community service concept, but it was in the concept of the Thakur. Just in the Alochana Prasange, the thing happened that one person complained to the Thakur. Thakur was at that time at Himayatpur, that the neighbor was stealing the fruits from the paddy field or from the other fields. Then asked the Thakur to punish that man. Thakur told him very well. That gentleman told that every day the gentleman was stealing the cauliflower or cabbage like this. The Thakur told him, very well, you offer him cauliflower every day in the morning. That person was surprised. Why, Thakur? Naturally, Thakur has said so, he obeyed that. He every day used to put one cauliflower. And from that day, there was no theft of the cauliflowers, nothing else happened. Then one day, that thief came to the Thakur, and he was very depressed and told the Thakur, this is happening every day, he is sending to me. I am sorry for that I stole, I theft everything from his field. Then Thakur told him, very well, if you are really sorry, repented, then you go and work for some time for him. And that is the social service Thakur rendered, and that gentleman was cured. They were friends of each other. And this is the concept Thakur introduced. We have to follow that path of Thakur, and then the society will be again cured, and from all evil we will be able to save our society. Thank you very much.
Thank you, Honorable Acting Chief Justice, former Chief Justice, Mr. Pratap Chandra Rai. Pratap Kumar Rai. And requesting the convener of the seminar, Devasish Bhattacharya, to deliver some thanks note.
I, as convener of this National Law Seminar, thank you all who are present and patiently hearing the speeches made by the eminent speakers. I also thank Jorashako PS, Jorashako Traffic Guard, Mahajati Southern staff, Canteen Service, Kolkata Municipal Corporation, Public Works Department, eminent speakers, distinguished guests. Here I conclude by thanking you all. Now the session will be concluded by giving dhoni by the members of our group, VIDHI-VIDATH.
All the members of VIDHI-VIDATH are requested to come on stage, and all the members, all the participants, I request to stand up and chanting the dhoni of Forum Das Thakur Anukul Chandra. And by this dhoni, we'll end the session today. Now, I'm requesting Mr. Vishwanath Gupta to give the dhoni.
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
परम प्रेममय श्री ठाकुर अनुकूल चंद्र जी की परम प्रेममय श्री ठाकुर अनुकूल चंद्र जी की परम प्रेममय श्री ठाकुर अनुकूल चंद्र जी की परमराधा जगत जननी शिशि वर्मा की परमराधा जगत जननी शिशि वर्मा की परमराधा जगत जननी शिशि वर्मा की परम पूज्य पाद शिशि वर्दा की परम पूज्य पाद शिशि वर्दा की परम पूज्य पाद शिशि वर्दा की परम पूज्य पाद शिशि आचार्य देव की परम पूज्य पाद शिशि आचार्य देव की परम पूज्य पाद शिशि आचार्य देव की सत्संग की सत्संग की सत्संग की वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे आर्य पितृं वंदे मातृवर्गं वंदे अहं कृष्ण दैवतं
वंदे अहं कृष्ण दैवतं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
वंदे पुरुषोत्तमं
परम प्रेममय श्री ठाकुर अनुकूल चंद्र जी की
जय गुरु
Joy Guru. Everyone are requested to take your lunch and all the members and giving all of them members the thanks from the VIDHI-VIDATH to be present here and all the associates, the YouTuber and the electrics provider, sound providers, all the members who have participated and helped us, giving thanks all of them. Thank you. I ending these sessions today. Joy Guru. আমি নিই নি একবারও